Greetings everyone. Igama labakhosikazi malibongwe. My name is Nombulelo Kumete. I am SABWiL's 5th Deputy President. I would like to welcome you in the words of Nelson Mandela when he said, education is a weapon that you can use to change the world. We are gathered here today in commemoration of a historic event, which is the signing of the Constitution, which was signed on the 10th of December in SABWiL by the late former President Nelson Mandela. The Constitution is a living document. It lives with us and it advances human rights. Since the signing of the Constitution, steps have been taken to reform and redress, such as ensuring that everyone has access to adequate housing, access to education, as well as access to courts. SABWiL is one of the organizations that promote the spirit and purpose of the Constitution. SABWiL is an international consciousness movement that celebrates South Africa, blacks, women, and law. We are founded upon equality, dignity, and the freedoms infused in the philosophies of Ubuntu and Vuk'uzenzele. And respect is integral to our core. SABWiL is regarded as one of the organizations that give the Constitution a voice. Yes, it's regarded as the organizations that give the Constitution a voice. It brings it to the ground, making it real and practical. The Human Rights Movement competition, it advances human rights, and it also creates awareness around different topics. They say not all heroes wear capes, and I truly believe in that saying. The act of service by our honorable justices who took time out of their busy schedules to come and educate and also to impart the knowledge that they have to future legal professionals is a heroic act. Their willingness to teach not only resonates with what Tata Mandela meant when he said education is a weapon that you can use to change the world, but it also resonates with the philosophies of Ubuntu, I am because you are. Ladies and gentlemen, this event not only commemorates the signing of the Constitution, but it also aims to educate and equip future legal professionals with the necessary skills required for practice. Our candidates were required to file written submissions as part of the selection process, and were also required to do extensive research and draft heads of arguments. So they have certainly earned to stand at the center of the Constitution today and moved in front of the justices. To the participants, thank you for hitting the chord. Without you today wouldn't have been possible. And I would like to remind you that at SABWiL, respect is integral. Although you are on different sides of the courtroom, please treat each other with dignity and respect. And I would like to leave you with a motto that helps me to navigate through life, which says, if you can't beat fear, do it scared. So please use today as an opportunity to learn and do enjoy. Malibongwe. Thank you guys.
Good morning, ladies and gentlemen. My name is Tiry. I am the former DSG for SABWiL, in the 4th EXCO. And my item for today is simply to render the opening remarks, especially for the participants that will be joining us today. I think it's most important that we first understand the reason why we gathered here. And we gathered here because we're here for a moot court. I don't want to call it a competition because it's more of a learning curve. So it then becomes prudent that I explain what a moot is. And a moot is a simulated court hearing in which the participants are then asked to analyze a program and thereafter research the relevant law that pertains to that problem. From then on, they will have to prepare submissions, as the Deputy President has said, and present the oral argument in relation to the submissions that they would have prepared. And today we're gathered to hear that oral argument and to find out about the preparation that the participants would have undertaken. And when we look at the SABWiL Human Rights Court, that the reason why we gathered here today, it's a different type of human rights court in that it remembers and celebrates the signing of the South African Constitution, which was signed on the 10th day of December in 1996 by the former President Nelson Mandela. So with this human rights court, the participants were then required to critically evaluate the provisions, rights, and responsibilities, as well as the limitations that are placed within the Constitution that we're here to commemorate. And with the submissions that we're going to get, we're then going to analyze and get to properly understand those provisions that are placed within the Constitution. And I think the participants of today would have been provided with a more in-depth understanding, and they'll also provide to us with a more in-depth understanding of the Constitution as it relates to Section 22. So with that, I thank you, and we'll then be moving to the next item on the agenda that we have. So I see the next item is the case scenario that is supposed to be rendered, but the speaker is not yet here. So I think they're still dealing with a bit of a logistical issue. So let me just find out what's going on.
Ladies and gentlemen, brothers and sisters, counsel, the applicant, the respondents, and our friends of the courts, amicus curiae, I greet you all. My name is Kululi Wekiswa. I am the 4th president of the South African Black Women in Law. I will be taking you through our case scenario today. First, I need to make this disclaimer. Our case scenario is fictional. The parties set out in this moot problem should not be seen as intending to reflect any real persons or organizations. We ask that you kindly assume that for the purposes of this court, that the facts set out below are accepted as correct. I'm here for this court. The applicant is Ms. Mapula Mweni. May the applicant's counsel please rise. Ms. Mapula Mweni was born in Mthatha, Eastern Cape. Her father is late, and she is raised by her mother, a father shopkeeper. She is the eldest of 5 children. The minister has filed a notice of intention to abide, while the legal regulatory council opposes the leave to appeal and the relief sought by Mapula to prohibit the considerations of those not permitted to practice law from the consideration into the training practice in South Africa. To join the proceedings as a friend of the court, they will be assisting the court in deciphering the problem that we are facing today. They wish to advance the rights, this is their motto, they advance the rights of refugees and others living in South Africa who have to secure permanent residency. Ms. Mapula, in all her life dream, was to advance the rights of those in her community that are so basic that the basic needs to be met. When water and electricity and the like are not accessible, Ms. Mapula wants to fight the rights of those who need this kind of help. To do this, she worked tirelessly in her studies for her law degree. She uses a paraffin lamp light to study at night. She lives in a shack with her family. Her law degree is funded by the government's program at the university where she studies, with the money from the public offerers raised through taxation. Wonderfully, with the support of her family and tireless efforts, she was awarded her law degree. She now wishes to train as a legal practitioner into the South African legal system. To do this, she learns that she must pass and complete her practical vocational training and pre-examinations by the Legal Regulatory Board. Excited, she applied. And after completing her academic journey to participate in the candidate legal practitioner program, taking joyous steps into her dream, her application to train was denied. Ms. Mapula knows that several applicants who are not South African citizens and without permanent residence, who are from the non-South African land, are accepted into the training program for legal practitioners. Ms. Mapula is also aware that many friends who are not allowed to enter into the training program for candidate practitioners they are always based on lack of capacity. Ms. Mapula Mweni, thank you, Council. She's the first law graduate in her family. The respondents are the Minister of Justice and Correctional Services and the Legal Regulatory Council. May Council for the respondents, Ms. Marais. Thank you, Council. The Friendly Foreign Lawyers Association, represented by our amicus council. Thank you, Council. For about 10 applicants, only one is chosen based on the limited capacity in the field. To adequately train all. Given this, we will also be taking a look into the Rufeneke case, which has been decided recently. This is Rufeneke and others' Constitutional Court decision in 2002. This is the most recent case that dealt with the issue of non-South African land citizens to practice law. Ms. Mapula feels frustrated, and I'm sure we can all understand why. She has worked tirelessly all her life. She has given herself the dream and worked towards it. She's given herself a task to fight for the rights of those who do not have a voice, who do not have access to the system. It is based on this reason that Ms. Mapula brings this application today. And we hope that during the deliberations and the deliveries by both council and the friend of the court, this court may be assisted in addressing the issue of non-South African citizens who wish to practice law and better the lives of their families and themselves in the future. Not only better their lives, but also fight for the rights of those who are voiceless. This is a call of the South African black women in law to fight for those who are voiceless, to speak for those who cannot speak for themselves, to advance the philosophies of Ubuntu and Zenzele. This is why we are here today. I hope that our council has prepared. I heard there were sleepless nights. It's part of the profession. Welcome aboard. In this application that has been launched today, we hope that you will keep in mind the purpose and object of the Constitution, enshrined in the Constitution the right to free trade, the right to education, the right to access to free education, and the right to practice a profession that you wish. With this in mind, we would like to welcome all our council and welcome you all to today's case.
In the Constitutional Court of South Africa, we call case number 912 of 2023, Marais SC as the applicant and Minister of Justice and Correctional Services as the first respondent, Legal Regulatory Council as the second respondent, and Friendly Foreign Lawyers as amicus curiae.
As the court pleases, my name is Cheryl Zulu. I confirm my appearance on behalf of the applicant alongside with my co-counsel.
Yes, thanks, Ms. Zulu. You may proceed.
Honorable Justices of the Constitutional Court of South Africa, esteemed members of this honorable court, today's case stands as a testament of the foundational principles embedded within the heart of our Constitution. It brings forth a dilemma steeped in the pursuit of justice, equality, and fundamental rights enriched within our nation's guiding document. At the core of this matter lies an unwavering determination of the applicant, a diligent aspirant who aspires to become a legal practitioner in South Africa. Her aspirations, fueled by the desire to champion the rights of the community, are noble and rooted in the very essence of justice and equality. The crux of this case centers on the pivotal intersections between the right to select one's profession safeguarded under Section 22 of our Constitution, and the broader principles of dignity and equality enriched within Section 10 and beyond. The applicant firmly asserts that the current dispensations infringes upon these fundamental rights by constraining her access to a profession she passionately aspires to be, despite her hard-earned qualifications and dedication. The Legal Regulatory Council, in defense of its practices, underscores the importance of inclusivity, aiming the historical disparities within the legal frame, while advocating for the inclusion and underrepresented groups. They are met with a challenge of extending these opportunities to individuals from non-SA land, a group facing unique circumstances. However, in pursuit of balance and fairness, the Council's stance intersects with the profound question of rationality and allocation of resources. The proposal to redirect the aspirants of this individual towards consultancy, while seemingly accommodating, raises the query of whether it truly upholds the spirit of justice and equality that our Constitution has embodied. Honorable Justices, this case stands as a pigment reflection on the delicate balance between inclusivity and allocation of limited resources. It implores the esteemed court to deliberate upon the essence of justice, dignity, and equality, and thereby determine the rightful course that aligns with bedrock of our constitutional values. Honorable Justices and esteemed colleagues, the focal point of this case revolves around the admissibility criteria for legal practitioners training programs. Specifically, we delve into the conundrum of whether practitioner programs considerations solely based on merit, gender, and race should expand to encompass citizenship and residency status, especially post the case Wathint'abafazi and others versus Minister of Justice and Correctional Services and others. Section 22 of our Constitution, a safeguard for citizens to freely choose their occupation, is fundamental. It not only grants the right but mandates the state to regulate professions. Our stance aligns with the decision of the Constitutional Court in Wathint'abafazi and others versus Minister of Justice and Correctional Service and others. The applicant, despite possessing the LLB degree, faces rejection based on capacity, while non-South African citizens without permanent residence gain entry into legal practitioner training programs. This, we contend, curtails the applicant's right to choose an occupation, allocating resources and opportunities to individuals unable to practice. The Constitution mandates rational regulation. In Affordable Medicines Trust, it was highlighted that such regulation must serve a legitimate government purpose. Wathint'abafazi versus Minister of Justice and Grootboom, the mutual reinforcement of constitutional rights and states' obligation in respect citizens' choices. In the Wathint'abafazi case, the ruling by the Constitutional Court in 2022 set precedent, yet our case delves deeper into training aspects for aspiring legal practitioners. The crux lies in the rationality and fairness of restricting training opportunities solely merit, gender, and race against the integration of citizenship and residency status as additional factors. The applicant's argument spotlights the allocation of resources, contending that these resources should aid those capable of contributing to the rule of law and human rights within South Africa, rather than those unable to practice law in the country. The Legal Regulatory Council defends its criteria, citing the imperative of inclusivity, especially for historical marginalized groups, justifying their approach as rational and explicitly stated. This case urges the court to harmonize constitutional values like dignity and equality and the rule of law, while weighing necessity for transformation against the judicious use of limited resources in legal education and professional practice. The exclusion of individuals from non-South African land from legal practitioner training serves as a legitimate governmental objective tied within the regulation and integrity of South Africa's legal profession. It ensures the profession's quality and trustworthiness, upholding legal standards and safeguarding against complications arising from ineligibility to practice within the country. The court's verdicts necessitates a delicate balance, weighing constitutional rights, professional regulation, individual liberties, and the effective use of resources. It's imperative to assess whether absolute exclusion based on nationality aligns with the constitutional values of it's more appropriate to consider it as one of the several factors in the admission process, considering broader societal and professional context. This case intertwines constitutional values such as dignity and education. The applicant asserts that denying training opportunities infringes her right to choose her occupation as according to Section 22 of the Constitution and undermines the right to dignity as according to Section 10 of the Constitution inherent in one's chosen profession. The court faces the task of navigating the balance between ensuring education and opportunities for South Africans like the applicant, addressing historical disparities and integrating individuals from non-SA land into certain spheres despite their inability to practice law in South Africa. We urge the court to examine whether permitting those unable to practice law to train as legal practitioners infringes upon the rights of eligible South African citizens, particularly those from disadvantaged backgrounds. We urge the court to evaluate this matter rooted in constitutional integrity and justice for all. Thank you.
Okay, let's just start with this aspect, and that is, it may be helpful if we have a profile for the person that you want to exclude from the program. So the idea is that there's a foreign person who at the moment may be taking up a seat on the training bus and therefore exclude your client. But let's consider who that person is from non-SA land. And let's assume the following, and that is, that person is simply a clone of your client. Same race, same gender, same everything. Same background, same difficulty in getting where she is, and the same aspirations. There are only two differences. The first is that your client is a South African citizen and resides here, whilst the other person does not have permanent residence, but probably or possibly only has a student visa. Because we agree that even if you're a foreigner, if you have permanent residence here, you can practice, be admitted as an attorney or advocate. Do we agree about that? Did you say yes? Yes. So we must assume that the foreigner, so to speak, has a student student visa, or alternatively only has a limited work visa, which means that sooner or later that person is going to have to leave the country. That's the one difference. The other difference is that seemingly that person is slightly more meritorious in being on the program than your client, because the LCR has chosen her above your client.
Ms. Zulu, thank you for your heads of argument and thank you for your oral submissions. I would like to ascertain from you, as a follow-up on your Section 22, you've raised that your client has grievances, that Section 22, right to trade and occupation and choose the profession, is impaired because we now have those from non-SA land also being considered in the training process. We've all read the heads of argument of amicus curiae, the applicant and the respondent. I see that the respondent raises in its heads of argument quite vociferously, and likely supported by the amicus curiae, that Section 22 is not really implicated in the case of training. So I would like to hear your submissions on, is Section 22, as the respondents and supported by the amicus curiae, is this really the right, is this implicated in the training scenario? Does it confine itself to only employment, as the respondents and the amicus curiae would want us to find? Or what is your submission on the ambit of Section 22? How far does it extend? And if, let me hear your submissions on that.
When analyzing Section 22 of the Constitution, it means that while Section 22 guarantees the right to trade, occupation, and profession freely,
do I understand your submission to be that Section 22 is implicated in training as well, and not only in practice of your profession?
yes, it is.
And your reason for your submission? Why do you say, what is the rationale for your thinking, your submission? Why do you say that training is included in the Section 22 citizens' right to choose their trade, occupation, and profession freely?
Because training would then be considered as a profession, as training leading to the profession that you'd want to further on, or the profession that you'd want to.
What is your submission on, does the practical component, the training aspect, is that better suited to the Section 29 right to further education? The reason I ask this is because Section 22 is a right applicable to citizens, and that has been thrashed through thoroughly by the courts, so there's no contention about it being a citizen's right. And this is what most countries in the world do to protect their citizens. So citizens have the freedom of choice on trade, occupation, and profession. Well, the Section 29 right accrues to everyone, not only citizens. So it is important for us to understand your submissions on where we couch this particular training, or is it such that it overlaps? So you've submitted it that from the applicant's perspective, the practical component is close enough to the trade, occupation, and practice, and hence within the ambit of Section 22. What do you say, particularly now, having submitted on Section 22's context? What I would like your submission on is not only on Section 22, speak to me on your submission, taking into account that a Section 29 right exists. Shall we just ignore that right and say Section 22 is so strong that it overshadows the Section 29 right? Is that your client's case? Or do we follow the traditional thinking and establish precedent that all rights have an impact and must be taken into account equally and have an interplay? Why is your client ignoring Section 29?
Our client is not ignoring Section 29. Our client is just concerned that these programs are offered to people who are non-South African, whereas they do not get those opportunities. So our client feels that their right to choose a trade freely has been infringed, and that these opportunities should be given to South Africans who can not only train but be able to practice also in the country.
Given Rafoneka, can a person from a non-South African land that cannot be admitted and enrolled be within the purview of Section 5J, which is the section that says the object? Can they be within this objective of the Legal Practice Council to grant accessible, to ensure, the wording is ensure, accessible and sustainable training of law graduates aspiring to be admitted and enrolled as legal practitioners?
If they are not citizens of the country and do not have residency of the country.
So what is your submission on that in a sentence, not simply with not? Tell me what your submission is.
My submissions are, with regards to that particular section, these applicants can be admitted if they are citizens and have permanent residency of South Africa.
So do I understand you correctly that this section clearly, expressly indicates that the objective is for those that aspire to be legal practitioners, and it doesn't stop there. It says aspire to be legal practitioners and admitted. They're aspiring to be admitted and enrolled. So can a person from non-South African land, in light of Rafoneka, aspire to be admitted and enrolled as legal practitioners?
No, they cannot.
So why did you couch your argument on Section 22? Ignore Section 29 lightly, without truly establishing facts in Section 29, and have no regard to Section 5J of the legal practice.
Because we are submitting to the court that these programs should be allocated to persons who will be able to train, to persons who will be able to practice even after the training.
Does this section, the object of the council, is it assisting your client?
Yes, it is.
Does that not answer the question, or do you need to interrogate the veracity and the depth of Section 22 and Section 29?
Please repeat your statement, Justice.
Does Section 5J answer your question? Does it assist your client definitively? Do you need Section 22 and Section 29?
It does not assist my client in this matter because that specific section is open to everyone and not just citizens of the country.
Well, let's say 1,000 applicants apply. Only 100 are going to get in. Forget about the nationality. Only 100 will make it. But shouldn't 500 be able to make it? Or maybe the entire 1,000?
Should they not be able to make it?
Into the program. You know, isn't the LPC not performing its duties properly in terms of Section 5 if only 1 out of 10 are admitted, and they are restrained because of capacity, not because they're not good enough? You nod. Does that mean you agree with me?
Yes, I agree, Justice.
Yes, thank you. If I understood you correctly, you said that your learned junior will be addressing us on the other aspects.
Yes, that's correct.
Are we ready to hear submissions?
As the court pleases.
As the court pleases. As previously introduced by my co-counsel, my name is Ayanda Thandiwe Ndlovu, and I am appearing as the junior counsel on behalf of the applicant. As previously submitted by my co-counsel, I will be making the submissions that the permittance of those not allowed to practice, to apply and train as legal practitioners is a limitation to the applicant's Section 22 right, and the limitation to the applicant's Section 22 right is not justifiable. If I may please direct the court to page 11 to 12 of our heads of argument. The applicant submits that the permittance of those not allowed to practice law, to apply and train as legal practitioners is an unreasonable limitation to their Section 22 right. In making this assessment, I would like to refer the court to Ramakatsa versus Makushule at paragraph 70, where they held that the text in the Bill of a text of a section in the Bill of Rights must be read generously and purposely in order to give the right holders the full protection afforded by the guaranteed right. In the present case, Section 22 will be read, and the applicant submits that there has been a limitation to their right. Furthermore, I would like to refer the court to Rafuneke versus Minister of Justice at paragraph 72, where the court held that South Africa, being a sovereign state, has an obligation to protect the interests of its citizens. It has entrenched the rights of its citizens to choose their trade, occupation, or profession freely through Section 22 of the Constitution. This section also empowers the state to enact legislation to regulate freedom of trade, occupation, and profession. The applicant submits that the permittance of those not allowed to practice law, to apply and train as legal practitioners is an unjustifiable limitation to their Section 22 right, which reads that every citizen has the right to choose a trade, occupation, or profession, and the profession may be regulated by law. In this case, the applicant has obtained an LLB degree, which allows her to apply for training of legal practitioners, but application to train has been denied due to owing capacity. And there are people who are not South African citizens who do not have permanent residence who are granted the opportunity to train as legal practitioners. The applicant submits that those who are not allowed to practice law, to apply and train as legal practitioners is an unreasonable limitation in a manner where resources and opportunities are given to people who will not put them into use as they are not allowed to practice law. The respondents through their papers have admitted to admitting people who are not South African citizens without permanent residence, and as a result, that is an improper allocation of resources. The applicant submits that it will be favorable if these opportunities and resources are granted to South African citizens who will be able to practice law. That way, resources and opportunities will be used efficiently and there will be no limitations to their Section 22 right. If I may refer the court to page 12 to 13 of our heads of argument, the applicant submits that the limitation is not justifiable. In Labrio Dam, the court held that a person's profession is an important part of their life. The applicant is raised by a single mother and 5 siblings, where she is the first to graduate in her family. Her completing the training will grant her the opportunity to be able to practice her profession. It is not reasonably justifiable to limit the Section 22 right, as it is a vital aspect of her life and a way in which she can better the life of her community and family that is unprivileged, as there are instances where she had to study using paraffin lamp while in a shack. In Affordable Medicines Trust versus Minister of Health, the court held that the Constitution requires that the power to regulate a practice of a profession should be exercised in an objectively rational manner that is related to a legitimate government purpose. The applicant comes before this honorable court that they find the permittance of those not allowed to practice law, to apply and train as legal practitioners, as an unfair limitation to their Section 22 right. Furthermore, in Baker versus Financial Services Conduct and Authority, the court held that the right to choose one's trade includes the right to practice it. Any law which prohibits a trade altogether or bars any citizens from practicing limits this right. Such limitation is unconstitutional and invalid unless it can be justified in terms of Section 36 of the Constitution. Therefore, The limitation posed by the issue is not justifiable. The applicant has obtained her degree, which permits her to train and practice, but it has been limited because there are people who are not allowed to practice law to apply and train for this program. To elaborate further, in Wathint'abafazi versus Minister of Justice, the court held that it should be, however, highlighted that because citizens have a right of choice under Section 22, the state should respect this right. The limitation of the applicant's Section 22 hinders the ability of the applicant and her friends that toil tireless in challenging environments given the legacy of apartheid, with studies funded by the government who have to now compete for limited training spots with those who cannot practice law in South Africa. This displays an unfair allocation of resources, and it is unreasonably justifiable. In closing, the applicant has as the court pleases. In closing, the applicant has argued that there is a crucial intersection between the allocation of training opportunities and the right to choose one's profession. The applicant's fervent plea for a fair distribution of resources highlights the conflict between the aspirations of dedicated individuals like herself, supported by government funds, and the inclusion of candidates from non-SA land who cannot practice law in South Africa. This case is not merely about the capacity of training programs that the LRC is faced with, but is a matter of discrimination that those who are not allowed to practice law are permitted to apply and train as legal practitioners than those who are citizens and can practice law in the Republic when they receive proper training. This raises questions about the rationality and fairness of limiting opportunities for those who can genuinely contribute to the legal profession. Wherefore, the applicant prays that the Honourable Court grants the following order: that those who are not permitted to practice law to apply and train as legal practitioners should not be considered for the training programs for the candidate legal practitioners, that this Honourable Court's decision aligns with the Constitution's values and guide the deliberation to uphold justice for Mapula and all those striving for a future built on equity and inclusion. Any further or alternative relief that this court may deem appropriate. It is an unreasonable limitation because the Section 22 right is afforded to South African citizens and not non-SA citizens. So we are submitting that it is an unfair limitation in a manner where resources and opportunities are granted to people who do not have the right to choose their trade, profession, or occupation freely, as it pleases the court.
Now, on the assumption that resources weren't a problem, we were much richer, and I think they called the LRC in our example. If the LRC had more money, then many more people would have been able to train. So isn't that the problem? Which means that in our ideal world, all the South Africans who wanted to be trained would have been able to train, and the people from SA or non-SA land would have been able to train as well.
If it pleases the court, Your Justice, as I had mentioned, that the LRC, stated we say that we have submitted that the LRC has an unfair allocation of resources due to them being limited. The problem is the LRC and the limited use and the limited spots of training programs that are available. So if the LRC did have enough opportunities, then the program would have been more favorable to non-SA citizens. We are not disregarding that non-SA citizens should not be allowed per se to practice, but we're saying due to the limited resources, it will be more favorable if that South African citizens are considered more than the non-SA citizens.
But the question is, can someone's constitutional rights depend on the availability of money or capacity? Isn't the answer just that the LCR or the LRC should do a better job?
It is the duty of the LRC to do a better job. But at the same time, due to them having limited spots, this leads to the rights of South African citizens being limited.
Thank you so much for your submissions, and thank you for the heads of argument. In terms of the interlimitation, you've said that the regulation in your submission is an internal limitation. I would be hesitant to state that the human right is limited. It is simply regulated. Why do you make the submission that it is limited and already not, because limitations would be more encapsulated in section 36. So I would want to understand your submission on why it's immediate that this regulation that all legal practitioners must subject themselves to instantaneously is seen in your client's submission as a limitation to an entrenched human right. Are you not being too robust in that submission?
If it pleases the court, Your Justice, that was a mistake on my end. I meant to say that it is an unreasonable limitation. But in terms of internal limitation, we are submitting that it is an internal limitation in a matter that the Section 22 right only applies to South African citizens.
Do we need to entertain Section 36 given the case of your client? Or is everything encapsulated in Section 22 and the second sentence which deals with the regulatory powers?
If it pleases the court, I believe we submit that Section 36 should be also Section 36 should also be entertained because it does say that. Oh yes, it says that as I had referred to Becker versus Financial Services Conduct and Authority, that the right to choose one's trade includes the right to practice it. Any law that prohibits a trade altogether or bars a citizen from practicing it limits this right. And then such limitation is unconstitutional and invalid unless it can be justified in terms of Section 36 of the Constitution. And Section 36 of the Constitution, being the limitation clause, says that the rights in the Bill of Rights may be limited only in terms of law of general application to the extent that the limitation is reasonable and justifiable.
So do I understand your submission is that this barrier to this consideration by the Legal Regulatory Council of including persons from non-South African land is a limitation? It's a law of general application in terms of Section 36, a law of general application in an open democratic society.
Yes, Your Justice.
And thank you for your submissions. And what do we need to delve into Section 36? Is this decision of the criteria, the open-ended criteria of including non-South Africans in the admission process, this process by the Legal Regulatory Council, is this something that is part of the regulation mentioned in Section 22?
If it pleases the court, Your Justice, I believe that Section 36 should be referred to in terms of making the assessment whether it is whether it is an unjustifiable limitation or not. Yes.
Thank you for your submission.
Ms. Ndlovu, you have undoubtedly heard your co-counsel's submissions to this court. You have heard the questions put to your learned senior from this court. I see in the final page of your heads of argument, you ask this court inter alia for an order that aligns with the nation's values, the nurturing a legal system that champions fairness, promotes human rights, and acknowledges the historical context that shapes the pursuit of justice. And now I'm going to ask you what is perhaps the most contentious and difficult question, and also does constitute question 17.6 in the case study introduction. And that is, what is the appropriate remedy, assuming that this court finds in favor of your client? What is the order, what is the relief that you seek this court to award? How do we change this position, this infringement of Section 22 of applicants or people in the position of your client?
If it pleases the court, Your Justice, the relief
That we seek is that the relief that we seek is that the permittance of those who are not allowed to practice law to be able to apply and train as legal practitioners, the people who are not South African citizens and who do not have permanent South African residence, we submit that they should not be allowed to apply and train for these programs. Or should they be allowed to apply and train for these programs, they should meet the requirements that are met, that they should possess permanent residence. And favor should be granted more to South African citizens because they are protected by the Section 22 right.
Thank you.
Yes, and assuming that this court finds in favor and takes these submissions that you just made towards us and finds, in fact, in your client's favor on all three of these suggestions, what is the process that follows naturally or legally after that? What order will this court need to make? Because I'm sure you are aware this court cannot order that, although it can form some part of the court's consideration, to take these elements that you had just named into consideration, that cannot constitute the final order made by this court. What will that order and the relief, the remedy that the applicant will seek, what will that need to be?
If it pleases
The court, Your Justice, I believe that the relief should be that the LRC should look into their resources that they're providing, and they should expand more on them, so that way that resources and opportunities are granted to South African citizens first, and then also they should also be granted to non-South African citizens who have permanent residence. Thank you.
The court adjourns.
All rise.
If it pleases the court, my name is Catherine Makwara. I confirm my appearance on behalf of the first respondent, that's the Minister of Justice and Correctional Services. Okay. I'll be dealing first with the points in Limine, that is jurisdiction and agency, as well as make the first submissions under entry requirements for legal training to be limited to factors such as marriage, gender, and race. And secondly, that it is in line with the government's obligation to allow non-South African citizens to be enrolled in legal practice training.
Yes, but before you continue, which of the 6 questions are you going to answer?
17.1 to 5.
1 to 5. And do you also represent the Minister of Justice? Because I saw in the brief that the Minister abides the decision.
Yes, the Minister abides to the decision. However, our appearance here today is to just make our standpoint clear on the submissions that we make in relation to this issue. The second respondent, however, is opposing the leave to appeal by the applicant.
Yes, so just tell me again, what is the position with the Minister?
The Minister here is just making submissions to make it clear to the court that
they agree to whatever decision that this court is to make in line with notice of intention to abide. So we're just here making our appearance to make our point clear that we do not challenge the issue of admission of legal practitioners when non-South African to enrollment programs. And secondly, that is in line with the government's obligation, rather the minister's obligation, to allow individuals who are non-South African to be enrolled in legal practice training.
So does that mean that you only represent the first respondent for purposes of telling us that the first respondent abides? I understand. Well, do proceed.
Same, but different. A common cliche that quickly summarizes the application before this court today. The applicant argued that it's same. The interpretation of Section 24 of the LPA, as well as Rafoneke Court judgment, that it's same to be interpreted to overextend from individuals who are practicing as attorneys to now cover individuals in candidate legal training. However, what the respondent is going to tell you is that it is the practice of law that is restricted and not the learning of law. Thus, this is utterly different. If it pleases the court, counsel now like to make the first submissions in the points in Limine, that is the issue of jurisdiction and agency. The applicants as well as the respondent do not contend that this court does not have jurisdiction. Therefore, we do not want to belabor the court, as we have agreed sufficiently both parties that this court has sufficient jurisdiction to entertain the matter, as it involves an interpretation of Section 24, an implication of Section 9, and Section 22 as argued by the respondent. We'd like now to move to the issue of agency. In paragraph 9 and 10 of the case scenario, the applicants brought the first application in the Mthatha High Court on an agent basis. The application before this court again...
I'm sorry to interrupt you, but I don't think we're entertaining the question of urgency.
They pleaded it in their heads of argument, unless I have to...
No, I saw it in the heads, but we're going to deal with the matter and not strike it for urgency.
If please the court, does justice want me to make an explanation on the issue of jurisdiction, or should we leave it to the pleadings?
No, we're happy with jurisdiction. We're happy with the question of urgency. You can deal with the merit.
No problem. If it pleases the court, counsel now like to make the first submissions under the issue of merit, where we humbly submit before this court that entry requirements for legal training should only be limited to factors such as gender, merit, and race, and not on nationality as argued by the applicants. 29,981 is the number of admitted legal practitioners in South Africa as reported by the Law Society in 2022. 51% of that number comprises of white practitioners. 58% of that number comprises of male practitioners. Now one begs to ask, where does that leave black practitioners? Or worse, where does that leave black female practitioners? To fully elaborate on this point, counsel refers to the long title and preamble of the LPA, which says that the legal profession should broadly reflect the diversity and demographics of the Republic. This is also substantiated in Section 3, subsection A.3, as well as the objects of the LPA in Section 5A, where it says that the Legal Practice Council has an obligation to put measures to provide equal opportunities for all aspirant legal practitioners in order to have a legal profession that broadly reflects the demographics of the Republic. The applicants also contend in paragraph 7 of the facts, as well as paragraph 7 of their heads of argument, that indeed there's a need to include or for inclusivity. Thus, one can beg to differ that the applicant is biting the hands that feed her, as if to put the 1:10 ratio of people who are admitted, she has a better chance of entering the profession since she's black and female. Thus, in order for the profession to legally show that, or rather to show the diversity in demographics, the minister as well as the LPC are in line with the Constitution and the objects and purposes of the LPA to allow for representation in the legal practice in PVT training by putting individuals who are black or individuals who are female at a pedestal, unlike the issue of nationality. On the issue of merit is implied in Section 26, subsection A of the LPA, as well as Section 24 of the LPC rules. The first issue of merit is that one has to complete the LLB degree, that is common cause. The second now falls under demand and supply. Paragraph 6 of the fact states that applicants' admission was denied owing to capacity. It is common cause that indeed the demand of legal practitioners compared to the supply is not in tandem. In 2017, the Law Society reported that over 5,000 individuals graduated with an LLB degree, but only 2,800 were accepted into PVT. That number does not take into account individuals who graduated in 2016, 2015, 2014. Thus, it is common cause that on the issue where supply is more and demand is less, that merit becomes the ground that one should consider. Thus, other than the issue of nationality, where the applicants are arguing, or that they are saying that they are put at a pedestal, or that the issue of foreign graduates will lead to an opening of floodgates, is simply false and malicious. Council would now like to make the second argument on merits, that is that it is in line with government's obligation as provided by the Immigration Act and the Constitution to promote access to legal training. It is common cause that many LLB graduates who come into South Africa are enrolled under a study permit or they come under an exemption permit. This is simply the same case as in Rafoneke, where the applicants were either under the ZTP permit, the Lesotho exemption permit, or the study permit. This permit, in line with Section 13, subsection A2C of the Immigration Act, allows holders of the permit to undergo training linked to their field of study, which means if I'm an agriculture student, I'm allowed to take practical vocational training on a farm. If I'm in psychology, I can be allowed to work in a children's home. Thus, if I'm doing my LLB, I'm allowed to undertake candidate legal training. In part 6 of the LPC rules, the issues, or rather Rule 21 or 27, which regulates candidate legal training, is put under the heading education and training and not legal admission. That's simply as alluded to again in paragraph 57 of Rafoneke on page 23, that undertaking candidate legal training is simply an extension of the LLB. One, you are simply undergoing more practical knowledge of your degree. You are not working. Secondly, there is no direct link, as the applicants contended, that PVT equals admission. As Mr. Chajga, one of the applicants in Rafoneke, though having successfully completed his LLB, successfully completed his board exams, managed to undergo, or is now currently working as a legal advisor. In the case of the applicant, she says that in paragraph 4 of the facts, she wants to advance the rights of those in a community to access water and electricity. She can simply do that without even undergoing candidate legal training. Thus, there is no direct link or precursor to say that there's an arbitrary limitation of her right to work, as there's other avenues that she can explore to achieve her purpose or her end goal that necessarily do not have to do with candidate legal training. Thus, it will be a mockery on the minister's part to simply say that we've allowed you to enter the country under a study permit, an exemption permit, but we're no longer going to give you the full package that we promised you on your ticket of entry. That yes, you can study, but now you can no longer do the practical work that we promised you because, well, we do not want to inconvenience South African citizens. But however, the Immigration Act is specific that this applies to everyone who enters the country legally. And in the LLB degree, most people who are undertaking it, as I've stated earlier, do so under a study permit or an exemption permit. Thus, simply put, what the applicant is doing is conflating the issues of employment to that of practical legal training. Thus, we cannot allow the general to trump over the specific, in that they allow what they want an overextension of the interpretation of Section 24, which only limits the practice of law to now go into and dive deep and now extend that limitation to fall under the purposes of legal training. Thus, on behalf of the respondent, we humbly submit this court to not allow such a mockery of the Constitution, a mockery of the LPA, by allowing an overextension of a non-merit-based interpretation that the applicant is thus submitting before this court. With that, I will leave the further arguments in points 7.5 and 7.6 to my co-counsel.
Ms. Makwara, at the outset, may I just commend both you and Ms. Roda on an excellent set of heads of argument, very well structured and very useful to the bench. Ms. Mkwari, you raised and you submitted some rather shocking statistics pertaining to how the legal profession in respect of race is currently divided. And I think we can all agree that there is some painful statistics there, and especially regarding black female legal practitioners. Now, I want to put the following scenario or question rather to you. Isn't it precisely for this reason that there's already a lack of black South African female practitioners in the South African legal profession? Why then, for this reason, should South Africa as a country allow foreign black female practitioners to take up and further enlarge the gap between equality of female practitioners? I mean, in the current case in KASU, this applicant is a black female aspiring practitioner. It is precisely because of people like the applicant that this problem is currently faced in our country. And as you rightfully pointed out, race should be contended. Should we not as a country look to protect and promote our own? And in an attempt to close that gap in these very shocking statistics before aid is given to those other than our own citizens.
If it pleases Court Justice, I would like to disagree with you on the first part of the phrasing of your question in regards that with regards to PVT, it's not affecting admission. So the statistics are on admission and not kind of legal trainings. Thus, we cannot use the statistics to justify the limitation or rather how black female practitioners are because it's only for South Africans. These statistics are only applied to South Africans who are admitted and enrolled as of January 2022. That is the first part. The second part, I would like to refer to 5J of the LPA, which says ensure accessible and sustainable training to law graduates aspiring to be admitted, which means that if the individual is not South African eventually wishes to aspire to be admitted, certain steps have to be taken in. That is maybe their permanent residence or their spousal visa has to be upheld. So currently the statistics that are there are specifically for South Africans and not include foreign individuals.
No, of course, that I accept. And the statistics may have been worse, they may have been better. I'm merely referring to the fact that you did bring up this, which illustrates the problem, regardless of how bad or not the statistics are. The scenario I'm putting to you, or the problem rather, is that I think we can come to the conclusion whether the statistics are recent or accurate. I think we can still accept that there is a problem insofar as the numbers of black female practitioners or aspiring practitioners in this country are concerned. In other words, to put it bluntly and simply, there aren't enough black female practitioners in the legal profession. Right, so we've already confirmed, or we recognize that the legal profession has this problem. My question to you is, why make that problem an even bigger one by allowing foreigners to enter vocational training programs when we already have only limited spaces for people to fill those programs? Should we not in those cases look to promote our own citizens first and foremost before we look to fill the gap of those not members or citizens of this country?
Thank you, Justice. In interpretation to the term everyone, as the respondents argued that PVT falls under further education, I'd like to refer this court to Khoza versus Minister of Social Justice, where this court, Justice Mokodo, stated that everyone extends to non-South African citizens within South African borders under the purpose of interpretation, firstly. So the Section 22, right, where you are saying that the statistics are showing a disparity where we are going to make the situation worse, still does not apply because these individuals are under the banner of everyone under Section 29, which is the further education right, and not necessarily the right to choose trade and so forth. So these statistics currently that you're saying that we're going to make the problem worse, we're not going to make the problem worse because at the end of the day, even the LPA recognizes that in admitting now, when they're now being admitted and enrolled as legal practitioners, it now falls in line with the ambit and the scope of what the LPC tries to achieve, that is to ensure that the demographics reflect what? The statistics in South Africa. Furthermore, by now making them permanent residents, they are simply for other South Africa. So now that doesn't really weigh in the balance of saying they're no longer South Africans because they're now protected and have the same rights as South African citizens once admitted. So this does not create a problem where now we're saying these foreign admitted attorneys, because now they all fall under admitted attorneys as interpreted and stated under the LPA.
Well, that is, of course, assuming that they eventually do obtain permanent residency. Thank you, Ms. Vuk'uzenzele.
Yes, but are we clear enough on this? Getting back to my colleague's question, is that if the foreign student comes here for 5 years and then gets an LLB, does the PVT, and then goes back to wherever the person comes from, I agree with you if this is what you say, and that is, that's all for the benefit of that individual in that country. It may actually be useful for the person back in the homeland to have done PVT. But the question, though, is, in the end of the day, there was a berth on the bus, and the bus has limited seats, and that seat was taken by a foreign student, and ultimately that bus is going to produce one less preferred practitioner. Isn't that right?
Well, in referring to Rafoneke with the similar issue that Justice you've presented, Pabasa said that there's no evidence that has been proven to say that the proportion of foreign graduates with law degrees is so great so as to open the floodgates. There's simply not much evidence, because when they come in the country, they are fully aware that they don't get to be admitted attorneys. They are fully aware that the right to practice is limited because the law practice is restricted to South Africans. So that doesn't really make a question of space, etc., because they are fully aware of where their practice or where their LOB benefits end when they're in the country.
Yes, I don't understand that, because the question is, do they know that it ends at the end of an LLB, or do they think it ends at the end of PVT?
As again stated in Rafoneke paragraph 68, it says that an individual who enters into South Africa undertaking an LLB, where they have a foreign status, it's your own option whether you choose to go through PVT, or it's your own option whether you choose to go to board exams. It's your own option, again, to end at the LLB. But again, the position is that one should be fully aware that there is no privilege, or there's no certain guarantee that you're going to be admitted since you're on a study permit. That is the current position. So an individual who enters the country to undergo an LLB degree is fully aware of where their rights and privileges in entering the law profession end.
But
so
where is that?
That is now subjective to the individual, whether they want to end an LLB or undertake articles or write board exams. But if you're on a study permit or an exemption permit, if you choose to go the full road, you end at the board exams, and you can't be admitted unless you change your status.
Yes, but that all begs the question, and that is, where should it end? Should you be in a position, if you're a foreign student, to be in a position that it would go beyond an LLB? Shouldn't we be in a position where we say you can come here, study your LLB, and then you can't go further? We reserve the practice as an attorney or an advocate to locals, and in that process we would also limit your ability to do practical training in that way too.
Well, Justice, I beg to differ on that point, because simply put, when these individuals enter the country, I'm going to go back to refer to Section 13 of the Immigration Act, that your study permit or exemption permit comes as a full package. So right now, the minister will not be stepping into the bounds and arbitrarily limiting the individual's right now to go under PVT, since again it falls under the education basket or the training basket that falls under, goes hand in glove with the LLB degree. So simply put, the minister or this court, it would be irrational for this court to now say that it should end at the LLB degree only and not extend to the PVT or board exams. You undergo training linked to your work, but now we want to come in and say that no, we're going to end it or cut it out at the LLB. That's quite arbitrary, and we submit that that position cannot be adopted by this court.
Well, that brings us to the other question, that is in 17.2, and that is, what is the purpose of the government to allow foreign nationals to come to this country and use our resources to benefit themselves. Why are we doing that?
I would like to refer to the Immigration Act, where in the preamble as well as the objects and purposes it states that, if you just give me a minute.
Yes, but keep in mind that immigration is to come and live here.
Yes.
But we're now talking about a student visa.
Yes. And the position is that the student visa allows an individual to undergo PVT. And the preamble of the Immigration Act, which allows for the study permit to be provided for, says that it allows for the contribution of foreigners in the labor market as long as they do not adversely impact on the existing labor market, and a policy which allows for foreign workers in South Africa and training of the nationals. So again, the training for the South African nationals and the contribution of foreigners is attributed to the Immigration Act. So the government purpose is that it is in line with Section 7(2)(c) of the Constitution, where we have to promote and fulfill the obligations in the Bills of Rights, firstly, and secondly, by allowing these individuals to undergo PVT, we are fulfilling our promise that is made in the Immigration Act, that we cannot break away from.
Yes, but why can't the individual only get a student visa to study in the LLB?
So I beg your pardon, Justice?
Why can't the student visa be limited to studying in LLB?
Well, Justice, it will be, I would not want to delve in that argument because, again, we would like to deal with the specifics of what's currently provided for in the Immigration Act. And the Immigration Act provides for the learning part as well as the training part. That falls, I think, outside the ambit and scope of what this court is supposed to adjudicate on today.
Okay, now let's, you refer us to Section 13(2)(c) or something from the Immigration Act. But that hasn't been amended, hasn't it?
Sorry?
It has been amended. That's not in the Act anymore.
No, it is currently still.
It is.
Yeah.
There is a 13(2), but there's no subparagraphs anymore.
So there's a 13(2), but there's no?
Subparagraphs. It now says that a person who has a student visa may, to a limited extent, be allowed to work here. Which makes sense. Maybe if you're a student, you may want to flip burgers in the evening or be a waitress or something. But it doesn't say what you say it says. It did, but it doesn't anymore.
If I would refer to the old one, isn't it that the first part of the work, it says part-time and full-time work on vacation, etc. That is when you're not currently studying. And the later part now allows you to link your area of work to that what you're studying.
Yes, that's not in the Act.
Or then I stand corrected by this court.
I had a similar difficulty as my learned brother. And I'll read to you what the section says. So that's Section 13, and this is subsection 3(c) of the Immigration Act 2002. So it says, a study permit does not entitle the holder to conduct work, provided that, then there's Section A, there's Section B, and then C says, provided that the department may, comma, in appropriate cases, comma, authorize the holder of a study permit to conduct work as practical training in a field related to that of his or her studies. So if one reads the section, there's an additional request. So you may have your study permit, and that's been authorized. But according to subsection 13(3)(c), the department may, in appropriate cases, authorize that holder of the existing permit to conduct work as practical training in a field related to that of his or her studies. So your heads of argument and your submissions have been couched on the basis that the study permit automatically incorporate the practical component. And that does pose a difficulty on our reading, hence the questioning on where you find this section. And this is the section that I found independently, and my learned brother also found independently. So that's one of the difficulties. Prior to me embarking on other points, let me hear from my learned brother. So that's one of the difficulties. That would you like to address me on that, or do you have a section other than what we see before you as the Immigration Act on the study permits?
No, I will not address this court on that, because now if we're now diving deep into the department, it now falls under the Minister of Home Affairs. So it falls outside the ambit of the Minister of Justice and Correctional Services to make a determination on that.
Thank you. So that is the questioning on the study permit scenario. That's the statute. So study permit, according to what I read here, does not automatically encapsulate the practical training component. There's an additional application, and then leave is granted. It is only fair that I also query your submissions on two factors. The one, which we'll deal with, is what I dealt with the applicant, is the objects of the Legal Practice Council. So you've heard my thoughts to the applicant's counsel, lead counsel. The Legal Practice Act stipulates in section 5J that there are various objects that the council must fulfill. And the council must take measures to ensure accessible and sustainable training for law graduates that aspire to be legal practitioners and admitted and enrolled as such. So when we interrogate the Legal Practice Act, Section 3 deals with a purpose. The purpose is to ensure access to justice and representation from the demographics of South Africa. Raffinek has come and given us the interpretation of who may or may not be legal practitioners admitted. So we understand the purpose in the context of Raffineka, taking into account the demographics. But Section 5 is what troubles me, and I'm calling for your submissions because counsel is here to assist the court. I would like your help on Section 5J, which troubles me, and it says that the object of the Legal Practice Council is to ensure accessible, and not only accessible, it's sustainable training for law graduates. So it's not a BSc graduate, but a law graduate, not an aspiring graduate, a law graduate. So you must qualify, you're a law graduate. And then this law graduate, whom the Legal Practice Council has a duty towards to ensure accessible training, must then, listen very carefully, must be an aspiring legal practitioner. So they don't have to ensure accessible training for a law graduate that wants to be an academic. But they have to have accessible training for a law graduate that aspires to be a legal practitioner. And a legal practitioner, it doesn't end there. A legal practitioner who will be admitted and enrolled as such. Now that admitted and enrolled as such, one has to take into account the 2022 decision of Raffineka. So in this context, I find difficulty in that reading of incorporating a person from non-South African land to demand any right for access to this training, because the duty is more for those that have the right to be admitted, that are law graduates. So how do you satisfy my difficulty on that point?
All right. To answer your justice, I would like to verbatimly read Section 5J. It says, ensure accessible training of law graduates aspiring to be admitted and enrolled as legal practitioners. Firstly, it does not specify South African or non-South African law graduates, it specifies law graduates. Therefore, we can simply infer from a textual interpretation that these law graduates apply to everyone who has a law degree in South Africa despite nationality. Secondly is the aspiring part, and aspiring simply means, according to Merriam-Webster, desiring or working towards a particular goal. And to fully exemplify and substantiate this, I'd like to refer to one of the applicants in Raffineka, Mr. Tiry Nyane, apologies for my pronunciation, who, despite knowing that it was going to take him time, he was still aspiring to be a legal practitioner. Thus, there are other avenues apart from the study permit or the exemption visa that allows an individual who might not currently at the moment be allowed to be admitted and enrolled to eventually be admitted and enrolled.
So this is what I'd like. You are answering my question. So let's delve a little bit deeper. Aspiring legal practitioner, do we accept, is somebody that realistically can walk the road towards legal practice? It's not a dream. It's a realistical route. You have to have a law degree.
Yes, correct.
If I may just call the clock. Thank you for that moment. What do you agree that an aspiring legal practitioner in a reading of that is someone that has a law degree, realistically walks the route to legal practice?
Correct.
Now, this aspiration to be a legal practitioner of a foreigner that we now know through Rafaneka does not qualify. Is it a dream or is it a realistic expectation? Is it something that is objectively rational at this juncture? Because have they as yet, what steps have they taken other than studying and having the degree? So are they an aspiring legal practitioner that qualifies to be admitted and enrolled as such? Because that's the difficulty. This is the second part. It doesn't full stop at aspiring legal practitioner. It says aspiring legal practitioner who may be admitted and enrolled as such. So I'd like to just hear your thoughts on what is the differentiation between the dream that may never materialize and a wish. Because we clearly know that someone with a BSc that has a wish to be aspiring legal practitioner doesn't have this access to the training from the viewpoint of the Legal Practice Act. So why should we encapsulate a foreigner that we clearly know doesn't have the right to practice? Why should we take a further leap beyond a South African that does qualify and that has the law degree? Because we need to also, the duty of the Legal Regulatory Council or the Legal Practice Council or a regulatory body in terms of statute is to, in terms of the interpretations, is to be rational. And that rationality is tested objectively. So why can we make that leap for a foreigner and say that, well, this dream is rational objectively, and it's similar on par to someone that has a BSc or somebody? What is your submission?
Justice, I like that you use the word dream, simply putting that there's no time frame into this aspiring or desiring for one to achieve a particular goal, as that is the definition of the word aspiring is put in Objectives 5J. Simply put, what we're saying is that they are fully aware again that indeed it's not a one-way ticket, unlike their South African counterparts that as soon as I finish my LLB, as soon as I do my PVT and board exams, automatically I'm admitted. Again, it goes to the aspiring that there's no time frame to it. They are fully aware that for them to actually be protected or to enjoy the full benefits of the legal practice as admitted attorneys, then there's to be a change of status that has to happen. So it does not really matter, or we should not really dive in deep to see that they be protected because of a timeline, really. The end goal is that indeed they're aspiring to be, but how long it will take is subjective to them. So again, they're still protected under 5J.
So isn't this better placed in the sense that if the access is barred absolutely or becomes a factor to consider the foreign status, whether it's a factor to consider or an absolute bar, isn't this where it leans more to a factor to be considered in the admissions process? Because then it can be interrogated on how realistical the aspirations is of this foreigner that we know at that moment doesn't qualify. But if there's a realistical time frame, and they potentially, as my learned brother indicated, maybe that in 2 years' time they would be a permanent residence after having been here for a certain number of time, or having qualified, or perhaps they've been on a spousal visa. So shouldn't that then be factors that we take into consideration? I have difficulty with your reliance simply on the interpretation of aspiration in terms of the dictionary definition, because the statute itself has not left aspiring without a context. It has preceded aspiring with legal graduate. You need to be a law graduate, and then it says aspiring, and then it follows it with also a qualification. So you need to be a law graduate who who endeavors to practice and be enrolled as such. So it's clearly couched. So why should we be creative and be lauded and do further than what the actual reading is on the statute? That's what it says.
Correct. That's what the Act states. But if we go to 5A, it says that the LPA wants to regulate admitted attorneys and candidate legal practitioners, right? That's the first step into it. And the training part, which now goes under Chapter 5 or the Chapter 6 of the LPC rules, now lists down what should be done. But however, what we're simply trying to say as the minister is that the issue of the aspiration on the timeline should not really be restricted and say that maybe it's going to take you a while to be admitted just because of your current status. Again, if I answer the Chief Justice, that it is now subjective to the individual whether they want to pursue or go beyond the board exams, the PVT, to now fully benefit on the part which says that to be admitted and enrolled as practitioners as espoused in 5J.
I think what I'm hearing from you, and you may indicate if my understanding requires a different perspective, is that this is already a law graduate. So a law graduate has already spent many, many years studying that particular degree. So that's already an investment in this aspiration to become a legal practitioner. And if they then are willing to subject themselves and undergo the process and do the additional training, that is enough of an indication that this is not a dream but a realistic aspiration.
Well, there's not really a correlation to just say that just because you've done the kind of legal training and board exams, automatic admission. Again, one of the applicants here stated that they are working as a legal advisor. There are others that can be explored, but the Constitutional Court stated that the PVT sharpens the skills of the legal practice. It does not equate automatically to just say, just because you've done the PVT and board exams, automatically enrolled as an admitted attorney or practicing. So we simply cannot now cut down and say, you're making more investments into the PVT. Why then should we cut down on your admission part? So it's again subjective to the individual whether they want to go the full route or not. But again, there's no direct correlation to say PVT is equal to admission as an attorney.
Are you then advancing the submission that the training as a legal practitioner is beneficial in the roles of legal advisory?
Yes, it's not only restricted to being an admitted attorney.
Having been a practitioner for many years, I would indicate to you that a little knowledge is very dangerous knowledge, and to think one has that army of knowledge would, in my view, probably be a disadvantage. So sometimes you need years in practice to develop, and before you can authoritatively indicate that you have that practical knowledge. So until, it's like a language. You may have the legal training, but you need to practice to actually appreciate it and then be able to definitively speak and assist. So I would be of the view that you need more than simply legal training to say that is sufficient. It's a continual process. So I think we've debated this point enough. Let me just take you to my other query. But thank you very much. Your submissions have been exceptionally helpful, and it has shifted my thinking. And I want to thank you for that. Now, the other point that I'd like you to assist me with is Section 9, which deals with the right to equality. So everyone has the right to equal protection and benefit of the law. If we find that this particular access in training is limited, is this then, in the absence of the objectives read by Section 5, subsection 5J, to the exclusion of that, and not taking that into account, are we then asked to treat people unequally and just then differentiate, which may or may not be discrimination, in an application process? Are we then asked to authorize that by the applicant? Is the applicant asking us to say that we will not treat you equally before the law, and if we find that Section 5J is not a valid limitation on that right to differentiate and culminates in a lawful discrimination, then are we simply then being asked by the applicant, in the absence of Section 5, subsection J, to then discriminate between South Africans and foreigners in the application process?
Correctly put, so the respondent does agree that the applicant is allowing or seeking this court to create that differentiation. But however, their differentiation is not substantially supported. Here's why we say so. Because Section 9 starts with the phrasing everyone, right? And their basing is on the every citizen part. But in this particular circumstances, Section 22 is not relevant in that we're arguing rather a further education. Section 29 in its phrasing goes again to say what? Everyone. And the interpretation of everyone is again reiterated in Cause of the Minister of Social Development is that a South African citizen and everyone in these borders. So what they're simply trying to advance before this court is to allow a differentiation where in this particular circumstances it does not warrant so.
And dignity. What about the non-foreign, the person not from South Africa, that is allowed to train and not practice? You have knowledge and cannot be used. What is the impact on that? Is this not offensive to the actual? Should we actually be party to this assault on dignity if it is an assault? Is it painful if you have the right to practice up to a point, or you have the training, you have qualified, and simply because you are not South African, you cannot practice?
Council humbly submits that the right to dignity is not impaired.
I think before you answer that, is it do you anticipate for the average person in this particular situation, is it a painful situation?
Painful, yes.
It is, because dignity and your right to work is very closely related. If you cannot work and employ the skill that you have, it's one of the deepest pains. It fundamentally impairs your dignity. So why should we then be a party to that and assist foreigners to train? And remember, if they're still on the journey, they are not yet qualified. Do we not want to assist them and stop them and assist them in ensuring that they do not suffer their dignity?
Well, in this particular instance, this dignity is not really impugned in terms of their right to work, and here's why we say so. Because Section 22 in the later part of it says that each profession should be regulated by law. And the LPC, rightfully so, in Section 24, read together as Section 115, regulates it so. So simply put, they understand the terms and conditions that come with undertaking an LLB degree here. And the state is in its power and in its obligation to regulate the professions and reserve it for South African citizens. Thus, we really cannot have or divulge in the discussion or dignity of what happens whether they're employed. And furthermore, to just substantiate on that, paragraph 90 of the Rafoneke judgment, Justice Chiki said that the fact that they're not eligible, I read verbatim, the fact that they're not eligible for admission does not deprive them of the right to be employed in other capacities, provided they are in possession of the necessary documentation that's permits so to do illegally. So they still can work in different capacities.
At that point, because I am persuaded it not affects your dignity, because we're not a nanny state. So the individual that is in that position is an adult and can make those particular choices. So we do have that autonomy of self, and our Constitution advances the human rights to dignity and the achievement of equality and freedom. So I'm satisfied on that point, and I want to thank you very much for your submissions and the excellent heads of argument of the parties. Thank you. I have no further.
This is the court. Counsel will now leave the
No, sorry, I still have a question also. And that is that you dealt with the question of demand and supply. And I think what you're saying is that there's an oversupply and a smaller demand. But when you determine that amount, the extent of the demand, is that the extent of the demand of practitioners in practice, or is the demand not only limited to the number of practitioners that the LRC can train?
The issue of the demand is not extensive to individuals who require legal services. It's for individuals who will be able to train them.
Yes, which means that, we call this the bus. So there's not enough room on the bus for everyone. But the question is the bus as big as it should be? I mean, if the bus was twice bigger, would those people not be able to find proper employment in legal practice?
Well, proper employment does not necessarily equate to admission as an attorney or advocate, Justice. So proper employment can be in other legally...
That might be, but that's not the question. The point really is that if the LCR can only train 500 people, that doesn't mean that in practice, if people were admitted, that practice only needs 500 people. There may be law firms looking around for candidate attorneys but can't find any because the LPC is not training enough people. For instance, is there any indication that if the many more people undergo the training, that if they were then to be admitted as an attorneys, they wouldn't be able to work? Okay, let me rephrase it though. And that is, if we take practice, that is the people that run around practicing law, there are a certain number of them. What is that limitation? I mean, how many people can make a living being attorneys or advocates in South Africa? Is that not more than the people that the LPC is training?
From the facts currently, the issue of recruitment is not literally restricted to the LRC. So it's either LRC has programs to train as well as individuals who have their own law firms. That is the first part.
So is the pressure point, is it's called something, there where the choking point is, isn't that the number of people that the LCR or LRC is able to train? I mean, if they were to train more people, would that be a problem?
That necessarily won't be a problem, but currently the resources do not permit them such. That is why we have to now consider merit, gender, and race as factors to admit the individuals, because currently the resources do not allow so.
Yes, but when it comes to resources, isn't 5G, isn't the idea of 5G of the Act that when it says put measures in place to ensure the training? Well, if you only train 500 people, then you're not doing what you're supposed to be doing. So if all the applicants that apply to do PVT, then the applicant can be admitted if if the LRC can only accommodate that many people?
Well, to answer you, I would like to pose this quote to the precedent set out in Grootboom, where the court stated that in a realistic world, we would have all the resources and accommodate everyone. But simply put, at the current moment, that is not so. So based on that, simply, that is why we're advancing that. In an issue where there's high supply and the individuals are able to train them, the demand is a bit low. Hence, we should advance the ground of merit, gender, and race to the individuals. That is, out of 1 out of 10 applicants who should be considered in that particular circumstances. In a realistic world, we would want to train everyone, but currently resources not allow. And this is not only specific to the Minister of Justice or the ARC, but every government department is facing the similar problem.
Yes, thank you. That looks like you're done. Your junior is going to take over from you now.
If the court pleases, I introduce myself. My name is Lino Roda, and I confirm my appearance on behalf of the second respondent, the Legal Regulatory Council. I shall be taking 7 minutes of the court to set out my submissions. But before I go into the submissions, I would like to point out a particular issue that the Council submits that the applicant's entrenched Section 22 right is not impaired because Section 22 right is not sufficiently raised by the applicant. Applicant didn't tell the court what is the nature or what are the elements of Section 22 right, how the training is related to those elements, and how then the training limits the applicant's Section 22 rights. Now, if the court pleases, may I go into my submissions? So just to make it easier for the court to follow, the Council would like to give a little small outline about that the Council is going to deal with first the matter of employment under Section 22 and under LPA. And Council would like to define the nature of the PVT and what candidate legal practitioners do, their activities when they're going through the PVT. And finally, the Council would like to conclude that these two things are not the same thing. So, but to come back to the first point about the employment and the ambit of Section 22. The Section 22 guarantees every citizen of South Africa to have right to choose their trade, occupation, and profession. So, interim constitution in its Section 26 clause to refer to this particular right as economic activity. So, and profession, occupation, and trade are defined as an activity allowing someone to take any kind of job, to render any kind of personal services, or hold any kind of position. In fact, High Court in Wathint'abafazi interpreted the word work. To work means that someone is conducting any activity formally associated with the running of a specific business. So the Council, thus to choose profession, trade, and occupation is to allow or render South African citizens to choose what kind of work they would like to do. Now, within the meaning of LPA, the Act does not particularly define what work means or what profession means. However, Act uses particular phrases such as to practice, to be enrolled, and to be admitted. Now, in Wathint'abafazi, High Court defined to practice and to be admitted and enrolled as such to mean that those individuals who are practicing, are admitted, are enrolled, those individuals are actually working. So the Act, justices, the Act, the LPA particularly and purposefully differentiates the two kinds of practitioners. We have legal practitioners and we have candidate legal practitioners. Legal practitioners are already in the position that they are working, whereas candidate legal practitioners, they are practitioners who are undergoing the training and they are in a position of learning how to work. So it's very similar to a nurse who is practicing in the hospital. The nurse is learning how to communicate with patients, learning the profession of nursing. So the principle is similar to that candidate legal practitioners. And what we are dealing now in this court, we're dealing with candidate legal practitioners. So the activities, the nature, what candidate legal practitioners do, although it's very similar to what legal practitioners do, they are different. For example, they cannot sign legal documents. They cannot appear to the higher courts, like High Court, Supreme Court of Appeal, and the Constitutional Court. Their appearing to courts are limited to the lower courts. The reason for that is that they can learn how to appear to the courts. So apart from that, so the PVT, when candidate legal practitioners learn the profession, their activities are regulated under PVT contract. The PVT contract sets out requirements and criteria as what they're supposed to do. They're supposed to do all, serve the principal. They're supposed to do all lawful instructions. So the nature of what they do is very similar to that higher education. Higher Education Act, Section 32, sets out the education system and breaks down into a few components. So in educational system, there are students who are supposed to learn, they're supposed to research, they're supposed to be under their supervisions and carry out the instructions of the supervisor or the lecturer and so on. So what they do is very similar to that higher education, what the higher education institutions actually offer to students. So in addition, Raffoneke High Court interpreted PVT as an extension of LLB degree. So LLB, the training is more inclined towards Section 29 to further education rather than Section 22 right for someone to choose their vocation, their particular profession. Apart from that, the further education is guaranteed to everyone, including foreign nationals, those who are within the borders of South Africa. Section 7 of the Constitution limits, puts duties on the state to promote, fulfill the Bill of Rights. Apart from that, Section 8 of the Constitution provides that the Bill of Rights needs to penetrate all laws, including the LPA. And Section 5 of the LPA makes a provision that there is one of the objectives that the Council needs to ensure that there is an accessible and sustainable legal training for all law graduates. Law graduates, the phrase law graduates are not defined or specified by the Act to mean whether those law graduates are graduated from South African universities or are they graduated from foreign universities. Thus, those graduates from foreign universities who ended up being in South Africa, they are part of the pool of law graduates under LPA. Thus, there is training is seen as a further education and is something separate from being admitted and enrolled. Thus, the Council is convinced that PVT and what candidate legal practitioners do, it does not fit within the ambit of Section 22 right. Thus, the respondents humbly submit to this court that to dismiss the applicant's case and uphold the High Court's decision, any appropriate remedy that this court might feel appropriate to order, and may each party pay their own costs. Thank you.
Thank you very much for the submissions. And I've already commended the heads of argument and for assisting the court in that regard. Can you assist further on the Section 36 limitation, which says we may limit rights, entrenched rights, by a law of general application in an open democratic society based on human dignity, equality and freedom. So what I want to ascertain from you, do we need to engage Section 36 in this inquiry?
Thank you, Justices. We do not need to engage with Section 36 because the applicant has failed to prove a threatened breach of Section 22 right, which means that inquiry is concluded. Because the applicant conflated the two issues, the PVT and formal employment.
I understand your submission that we need not engage with it because Section 22 is not applicable. Is that correct? That's my understanding.
Yes. There must be a clear right.
So Section 22 is not implicated, so there's no point in engaging Section 36. Assist me now with Section 9. So I leaped a little bit by interrogating Section 9, but we've laid the basis. Section 22, the respondent says not implicated. Section 29, the respondents are saying is implicated because that's a right to further education and that's closer to where we are in terms of training. It's more aligned to the LLB. Assist me with Section 9, which deals with equality of rights. Everybody is equal before the law, and there is the right to equal protection and benefit of the law. So if we are working on the applicant's case, and we differentiate and say, look, we treat non-South African citizens one way, and we treat South African citizens differently. Currently, everybody has the access to training. The applicant wants the access to training to be only afforded to South Africans that qualify as opposed to non-South Africans. There must be a curtailment from the applicant's case. If we find for the applicant and we limit, are we differentiating between non-South Africans and South Africans? We're treating them differently. You agree? The applicant wants us to treat South Africans and non-South Africans differently in the admissions process.
The applicant says that do not let foreign nationals enter into the training. So, yes, we're treating them differently.
The applicants wish for that. That's what they want. They don't want equal treatment.
Yes.
So, I know what your attitude, the submissions on Section 22. I understand what your thinking is with Section 36 linked to Section 22. I understand what your submissions are on Section 29. What would your submissions be on this request and this argument and submissions from the applicant that we need to treat parties differently, and that would be differentiation? Your case is that the respondents should have the access to the training. The case of the Legal Regulatory Council is that the foreigners should be allowed to train. Is that correct?
Yes.
Then the next step on that is that with Section 5J, which I've indicated to you, and you've heard me, it's only fair that, because that is one of my cardinal difficulties, that I've posed it to all the parties so you can make the submission. But because your task in this submissions to the court has been to deal with the limitations and internal limitations in the remedy, I must interrogate you about this and just hear your thoughts on this right to equal protection and benefit of the law that everybody has. It's entrenched. It's a human right. Everyone, not only a citizen. We all equal before the law. Is this then a differentiation when we look at Section 5J? When we look at Section 5J, it says, well, the Legal Regulatory Council, the Council must ensure that there's accessible and sustainable training by law graduates aspiring to be legal practitioners and admitted and enrolled as such. So they don't mention persons that cannot be admitted and enrolled. So access should, in terms of the statute 5J, isn't that something that already differentiates between foreigners and South Africans?
My understanding of Section 5 of the LPA is that access is related to law graduates. Because the Act does not differentiate who are those law graduates, and because of the transformative constitutionalism, we need to see this particular section not only to mean what the actual legal text says on black and white, but we need to see it in the wider purpose. So we cannot repeat what was in the past. We need to we need to be able to allow those law graduates that are within South African borders, to also have access to the PVT training, because we see PVT training as part of Section 29 right, and everyone has right to education. And in terms of equality, those foreign nationals' rights are also upheld by the Constitution. So we need to look at the LPA within the meaning of transformative constitutionalism of...
I appreciate the looking at the deeper aspect of transformative constitutionalism, because that's quite important. That is where we're headed. You know, the purpose of interpretation of the Constitution, we interpret it with the purpose of where we're headed as a nation. And I'd like to then, because you've mentioned that, shouldn't we then first look to the Legal Practice Act before we engage with the sections of the Constitution? If the Legal Practice Act can answer the questions here, do we need to take it further and engage with the Section 22 and Section 29 and Section 9 and Section 10 and the other sections? Answer that in principle. If the Legal Practice Act can definitively, on its own interpretation, satisfy the case, and if we find that answer in the Legal Practice Act, based on the principle of subsidiarity, do we need to interrogate further?
No, we don't need to.
Ms. Rodda, thank you. Fortunately or unfortunately for you, my learned sister has canvassed the issue with you that I wanted to. Let me perhaps then just turn back to what I understood your address, your submissions to start with, almost taking the form of point and limine, if you will. Was I correct to understand that? That you attempted at the outset of your submissions to make the point that had this been an ordinary hearing and had you been permitted to, you would have argued that the applicant's case and application is based on an infringement of an incorrect right, that is Section 22, and for that reason, they are here on the incorrect basis, alleging the infringement of a right which has not been infringed in this case, and based on that conclusion, the application ought to have been dismissed within, of course, the ancillary relief which you asked for to follow. Did I understand that correctly? Well, in this regard, may I say well done. I was wondering if someone would raise the issue or question at least whether Section 22 of the Constitution is in fact is and remains the correct section by itself. Of course, without taking into consideration the section dealing with education and 36. We were wondering whether someone will pick up that may or may not be the correct section on which to have approached this court. But I have no further questions for you.
Thank you very much.
Good afternoon, my justices. My name is Tsihetu Mklu. I appear on behalf of the amicus curiae alongside my learned friend, Mr. John Makinta, who's my junior counsel.
Coordinated. Yes, thank you. You don't have to worry about the microphone. Just go ahead. Thank you.
Yes, my justices. I appear on behalf of the Friendly Foreign Lawyers Association, whose intervention in the current proceedings is primarily aimed at assisting this court in advancing the rights of the legally recognized non-South African citizens living in South Africa who have yet to secure permanent residency or citizenship. The Friendly Foreign Lawyers Association has an interest in the outcome of the current proceedings as it will adversely affect foreign nationals who would like to enroll for PVT programming, practical vocational training. The Friendly Foreign Lawyers are of the view that the exclusion of foreign nationals from participating in PVT training would like to bring it up to the court that this unjustly limits their constitutional enshrined rights to equality, human dignity, and education. I would like to focus on the arguments in regards to rights of equality and rights to dignity of these of the non-SA land citizens, and my junior counsel will focus more on their right to education. That's how we would like to bring forth our arguments. I'd like to begin with a quote from a case, the Canadian Supreme Court in Andrew. Relative to citizens, non-citizens are a group lacking in political power and as such are vulnerable to having their interests overlooked and their rights to equal concern and respect violated. They are amongst those groups in society to whom needs and wished elected officials have no apparent interest in attending. The characteristics of citizenship is one typically not within the control of the individual, and in this sense is immutable. Citizenship is, at least temporarily, a characteristic of personhood, not alterable conscious action in some cases, and not alterable at all except on the basis of unacceptable costs. I'd like to mention Section 9(1) of the Constitution that provides that everyone is equal before the law and has the right to equal protection and benefit of the law. Section 9(3) lists certain grounds which, to be found, someone is discriminated on those grounds is found to be unfair automatically. While citizenship isn't one of the listed grounds in Section 9.3, it is a ground where it is possible that objectively, if discrimination is based on it, it can impair the fundamental human dignity of human beings and can affect them adversely in a serious manner. This differentiation may amount to discrimination, and it could be found to be unfair discrimination. One of the points a party who wishes to discriminate on one of the non-listed grounds, if the discrimination is let me take a step back. So obviously citizenship is not one of the listed grounds according to Section 9.3, which means that it needs to be found out, a ground needs to be one where unfair potential discrimination that may affect their human dignity may be found, which citizenship can be identified as that. And from that point, it's the other party must allege that that discrimination is just, either through Section 36 of the Constitution, or if they can relate it to government's to a legitimate government purpose. And if they cannot, then that would be a violation of Section 9.1. We just like to make the court aware that the applicant's argument to not consider non-SA land citizens to participate in the training program for candidate legal practitioners bears no rational connection to a legitimate government purpose. The power to regulate a certain professional trade should not be done in an arbitrary manner or to manifest naked preferences that serve no legitimate government purpose, for that would be inconsistent with the rule of law and the fundamental premises of the constitutional state. Government action must be exercised in a way which is in favor of the public good and enhances coherence and integrity of legislation. It is common cause that Section 24 2B, read with Section 115 of the Legal Practice Act, precludes persons who are neither citizens nor permanent residents of South Africa and who are not admitted as legal practitioners in designated foreign jurisdictions from being admitted and enrolled as legal practitioners in South Africa. That is common cause. However, we should still not allow these. We should still not ban these non-SA land citizens from enrolling in PVT training. The South African state allows non-citizens and non-permanent residents to study law and graduate universities across the country. The fact that non-SA land citizens are not eligible for admission does not deprive them of the right to be employed in other capacities, provided that they are in possession of the necessary documentation that permits them to do so legally. Further, citizens of non-SA land can, in the future, apply for permanent resident status, or in terms of Section 31 2B of the Immigration Act, can apply to the Minister of Home Affairs to grant them the rights of permanent residency for a specified or unspecified period if special circumstances exist. The argument that foreign citizens should be discriminated as the ability to return to their country of origin reduces their commitment to South Africa lacks merit, as this argument can equally apply to many thousands of South Africans who hold dual citizenship. Citizens of non-SA land have a right to be treated equally in front of the law. Their ability to enter the Candidate Attorney Legal Program training, PVT, should not be stopped on arbitrary grounds which do not follow a legitimate government purpose. Even though citizens of non-SA land cannot be admitted as attorneys, they may enter other fields of work where receiving training from the PVT training may be advantageous to their careers. I now want to highlight the right to human dignity. Human dignity is one of the cornerstones of our Constitution and is inherent to all human beings. The right to human dignity is enshrined in Section 10 of the Constitution, where it is stated that everyone has an inherent dignity and the right to have their dignity respected and protected. Section 1 of the Constitution states that the Republic of South Africa is one sovereign democratic state founded on the following values, which are human dignity, the achievement of equality, and the advancement of human rights and freedoms. The fact that the Constitution refers to dignity as being inherent is evident that it is not a right granted by the state only to citizens, but is something that is attached to a person by virtue of the fact that they are a human being. In this sense, the Constitution aligns itself perfectly firmly with the international human rights discourse and demands transformation in our society from an oppressive past to a future where the inherent worth of all people is upheld and celebrated. Dignity as a value is often attached to a constitutional claim of infringement of a more direct rights. For example, one could bring a claim for the breach of a right of equality, where the linking value would be someone's right of dignity also being infringed in the matter. I just also like to highlight a quote from the Hugo case, which highlights the fact that one's right to choose what to study is so inherently linked to their dignity. At the heart of the prohibition of unfair discrimination lies a recognition that the purpose of our new constitution and democratic order is the establishment of a society in which all human beings will be accorded equal dignity and respect regardless of their membership of a particular group. The achievement of such a society in the context of our deeply inegalitarian past will not be easy, but that this is a goal of the Constitution should not be forgotten or overlooked. Citizens of non-SA land... Oh, okay.
Oh, is that what that was? I thought I had to wake up. Yes, how much longer are you going to be, Mr. Martin?
No, I was basically finished, my justice. I just wanted to highlight the fact that citizens of non-SA land have a right to have their innate human dignity recognized and protected, and that arbitrarily infringing their right to human dignity, prohibiting them from receiving education and training, which they are entitled to by immigration law, would be hugely damaging to their freedom to choose a vocation and ultimately their right to human dignity. Thank you.
Mr. Botlung, we thank you for your submissions. I want to refer you to paragraph 9 in your heads of argument. Here you touch on the issue of differentiation. If we have regard from sort of the middle part of the paragraph towards the end, it reads, the result sought by the applicant in this matter carries the potential in resulting in an arbitrary differentiation that will have the potential of impairing on the fundamental dignity of persons as human beings or affect a group of people in a comparably serious manner. Now, this group of people, am I correct in assuming that you are referring to foreign students in this case? Right, now, taking into consideration for the moment your view in saying that if the applicant is correct and if relief should be awarded to the applicant, the relief that they seek, a group of people, to which foreign students will be affected. What do you say, however, about the rights of the South African citizens who are now not able to attend vocational training? What do you say about them as a group of people and their rights being affected? Because let me perhaps make it a little more clear. It seems almost in this case that we have, and again accepting for the moment that the applicant had approached his court based on the correct infringement of the rights described in the correct section, we seem to have two equally important constitutional rights weighed up against one another. How do we sit back as a court and determine which group of, we have two groups of people clearly who are being affected by this issue. One is the foreign students, and the other, of course, the South African citizens who feel that they are not able to get into vocational training, as we've quite, to some extent, laid out. My question to you is, how are you able to assist this court in saying that one group of people's rights are being affected, but what about the other side, the opposing side? What about you that to say about their rights being affected?
Yes, my justice. As you correctly point out, yes, South African citizens would bring up the fact that their path to becoming admitted attorneys is being blocked by the participation of foreign nationals. But I'd like to highlight the Grootblum case that held that no rights in the Constitution should be elevated above other rights, and that the rights contained in the Bill of Rights are mutually reinforcing. We cannot place the rights of South Africans above foreign nationals. It is true that this is South Africa, and there are cases where the government might want to implement certain legislation, laws that help protect South Africans. But in this case, these laws cannot just be made out of thin air. They need to have a rational government purpose. And we feel that stopping foreign nationals from studying PVT is not in any way related to any rational government purpose. As we've highlighted, as I think the respondents have also highlighted, the fact that even though they cannot be admitted, they can enter other fields of work, and they could also be gain citizenship or gain permanent residency in the future. We cannot just focus on the rights of South Africans solely and dismiss the rights of citizenships who are, of foreign citizens who are, as I've highlighted, very vulnerable.
Yes. Of course we cannot, but in the same breath we cannot elevate the rights of foreigners, obviously to the prejudice of South African citizens. Why I put this scenario to you, Mr. Motlung, is, isn't the answer perhaps that before we get to the whole question and before this one does become an issue of constitutionality, isn't there perhaps, doesn't the answer lie in Section 36 of the Constitution, which allows you to limit, or that permits certain limitations of constitutional rights, if you look at the purpose of the limitation, the extent thereof? Doesn't, as my learned brother and sister have quite correctly pointed out at some stage during the hearing of this application, isn't the answer perhaps that we should look to the LRA,
the LRC.
The LRC, as we refer to it in this case? Shouldn't we be looking towards them to either, as has been suggested, extend the number of applicants that can be taken into the learning program, so that we reach a stage that neither the foreign students nor the South African citizens' rights need to be curtailed, and we don't have to have the scenario where we have to weigh up which is more important than the other? Because, I mean, as I'm sure you do know, how does one begin to weigh that sort of importance and rights?
Yes, Justice, yes, I agree. That would be the most ideal situation if the LRC would be able to consider more applications from individuals who would like to do PVT training. Be that as it may, the LRC they have decided that you cannot become an admitted attorney if you're not a citizen or permanent resident, but there's no anything prohibiting these same individuals from non-permanent residents, non-citizens from studying the PVT. But yes, in an ideal world, it would be very advantageous, ideal if more opportunities were given to people who would like to study, undergo PVT training.
Thank you, Mr. Motley.
Thank you for your submissions. It's been very useful. The heads of argument as well. I clearly was able to ascertain that you focus on Section 9 and the right to equality. So thank you for that. And that is the duty of the amicus, is to bring something that the other parties have not put before the court, either through fact and law, and neither the applicant nor the respondent delved into Section 9. So thank you for that. It assisted in the preparation and deliberations. Is that the cardinal point, that Section 9 and Section 10, is that the contribution of the amicus curiae? What is the thrust of the contribution of the amicus curiae to the case, on fact or on law?
On both fact and law. The amicus curiae is to bring up points of law that maybe.
No, I mean, in this particular circumstances, what is the nub of your contribution to this case? Seeing that you're the amicus curiae and not the party.
Oh, what is our contribution? Yes, we spoke on the rights to equality and rights to dignity that non-citizens and also non-permanent residents have.
But for what purpose? Is it to advance transformative constitutionalism, or what is? I know you're relying on those rights, but for what purpose? To what end?
It's to the friendly foreign lawyers don't believe in creating prohibitive laws, yes, against non-SA land citizens.
That brings me to the point. Now I understand. So in other words, we should not have a restrictive interpretation of the Constitution. We should be expansive in terms of how and endeavour to ensure that all and everyone has the most access to human rights as possible. On that vein, isn't it salutary to allow anybody and everyone who wants to study the practice of the law to do so if they a law graduate? Because the more that individuals study how we practice, the more us being a leading constitution, with the leading constitution in the world, the more we can impact, and whatever laws we have here can be transcended globally. Isn't that an aspiration of any country, that their laws can manifest and have an impact globally, and by permitting foreigners to train and study, even if they cannot practice? Are we not advancing the South African Constitution and human rights through these individuals, wherever they may be?
Yes, my Justice, yes, that is yes, a good point. Yes, it does give foreign nationals.
That is your point, is it not?
Yes,
that we have. I saw that from your argument and the heads of argument. You've heard my problem, which was that if the Legal Practice Act in Section 5 is 5J says that the objects is to advance, to ensure accessible, and the terminology is ensure accessible and sustainable training for law graduates that aspire to be legal practitioners and be admitted and enrolled as legal practitioners. Then if we find that that answers the question, need we delve any further?
If
Section 5J basically says that the objective of the Legal Practice Council is to grant access, to ensure accessible and sustainable training of law graduates who aspire to be legal practitioners and admitted and enrolled as such. So the object is, this is the legal practice, it's express, it's Section 5J. So if we find that we can answer this case through Section 5J and the Legal Practice Act interpretively, do we need to interrogate Section 22, Section 29, Section 10, Section 9?
Yes, and legislation can still be questioned, like the LRA. Just getting to a point that the LRA is basically facilitating training for people who intend on being admitted.
That's what the section says. So my question to you is, it's very simple. If we find that that answers the question of the applicant and the case that the respondent is fighting, do we need to delve further?
Yes, I believe so.
It answers the question, but we still need to delve further. How does that make sense? My Justice, because the LRA's interpretation could still be prejudicial against non-SA land citizens, as has been made out, even though they can't practice as be admitted as attorneys, they can still enter other fields of work. They can still. What are you saying about Section 5J? I want to know.
Essentially, that it's we are not. We think that it's limiting, and it's dangerous to the non-SA land citizens, because essentially it's saying that the training should be focused on people who will eventually be admitted, and obviously we're aware that non-SA land citizens who are not permanent residents will cannot be admitted as attorneys.
There's no challenge before us on that section. It's the law.
Yes.
So all we can do is take into account the respondents' assistance in how to interpret that particular section, is it not?
Yes. Yes, my teacher.
Looking at the deeper interpretation of what is an aspiring legal practitioner.
Yes, my
and
teacher.
that must be rational and objective.
Yes.
Thank you. Thank you very much for your assistance.
Thank you.
My name is John Makinta, and I appear here on behalf of foreign-friendly lawyers. And as amicus curiae, we're here to vehemently oppose the applicant's position in the matter. It goes without saying that a foreign national, in whichever country they may visit, are in that country as an ethnic minority. In the international law arena, a minority is a separate and distinct group distinguished on the basis of race, religion, or language from other groups. In order for a group of people to be recognized as minorities, the collective must manifest sense of community and a desire to preserve it. The key element for such a classification is that the group must be in a non-dominant position. I will later explain what is meant by non-dominant position. The host state is required to protect the rights of the minority because it lacks the political power to do so. By analogy, the word community in terms of Section 31 of the Constitution refers to an identifiable group united by common religion, language, or culture that is self-consciously a community. Self-consciousness requires that the member of the group should identify themselves as part of the group, and members of the group should identify such a member as being part of their own. Non-dominance requires the community should find itself at odds from time to time with the rest of the community. In essence, the minority must not be the dominant culture in that state. One of the purposes of Section 31 is to enable such a community to preserve its distinct existence against the forces of discrimination or assimilation to which it would otherwise be vulnerable to. I start off my oral submissions with reference to minority rights because of today's matter relates to the limitation of a minority right, the right to education. Section 31 of the Constitution is referenced here in my oral submission to give context to what extent the Bill of Rights places an importance to minority rights. The Bill of Rights does not expressly mention as to what minority rights are. However, 3 sections of the Bill of Rights are specifically aimed at protecting minority rights. I have already gone to great lengths in explaining how Section 31 relates to minority rights. Section 30 restrains interference by state or by private individuals and institutions with an individual's right. So can I please repeat that? Section 30 restrains interference by state or by private individuals and institutions with an individual's right to use the language or participate in the culture of his or her choice. This section bears no relevance in today's matter. Section 29, the right to education in the language of an individual's choice and a right to establish private educational institutions, however, bears relevance in this matter. Section 29 of the Constitution forms the heart of our submissions. The section not only guarantees the right to education to everyone, but goes further in stating that everyone has the right to further education, which the state, through reasonable measures, must make progressively accessible. We want the court to take note that the section requires that the state act positively in promoting the right to education and making it progressively accessible. Additionally, Section 29 of the Constitution prohibits any interferences with the establishment and maintenance of such institutions. The desired outcome by the applicants to exclude foreign nationals from PVT programs and candidate attorney programs does not make the right to education progressively accessible in terms of Section 29. The enshrined right in Section 29 of the Constitution, the enshrined right in Section 29 of the Constitution owes its existence to international law. Much like Article 2B, 5B, much like Article 2 subsection B and Article 5 subsection B and Article 5 subsection C of the UNESCO Convention Against Discrimination in Education, the articles read together they request that state protect the minority rights by granting the right to create private educational institutes other than those maintained by public authorities. Much like Section 29 declares the right to education to be available only where certain minimum standards, including standards laid down as general education policy by the state, the article includes a further internal limit on the right by prohibiting the establishment of educational institutes that discriminate on the basis of race. Based on what I have said so far, immigrants and refugees do have rights as a minority, and in abiding by the international obligations, states are obligated to implement policies that safeguard these rights and in this way facilitate procedures to integrate immigrants and refugees into host countries' societies. Section 29 imposes similar obligations. Prohibiting nationals from PVT and candidate attorney programs is not aligned with the Legal Regulatory Council's duty to ensuring the quality and integrity of the profession's efficiency and maintaining public trust in the legal system. The effects of the Refoneke case judgment did not result in a complete barring of the participation of foreign nationals from appearing in our courts. The judgment only excluded foreign nationals from participating in candidate attorney programs, since Section 22 of the Constitution was silent regarding non-citizens' rights to profession of choice. Foreign nationals, in terms of Section 24 of the LPA, still had the right to appear in court as legal practitioners after application to the Minister for Right of Appearance. The judgment was still, my apologies. PVT programs are different in nature from candidate attorney programs significantly. PVT programs are not a requirement for law graduates in order to pursue a profession in law. Candidate attorney programs, on the other hand, are compulsory. PVT programs' main function is to merge the theory learned by law graduates with the practical application of the law. PVT programs offer participants the opportunity to practically apply the knowledge which the law graduate obtained throughout their years of study. Permitting foreign nationals to participate in such programs will improve the efficiency of court application brought by foreign nationals who have obtained the right to appear in terms of the LPA. And that is all.
Yes, thank you. We appreciate that. But maybe just one or two questions from me to start off with. And that is we have to be clear about this, and that is that the foreign national is the foreign national who's here on a temporary basis. It's not the immigrant. It's not someone who has permanent right of appearance. Permanent right of residence. Are we clear on that? Which means that this foreigner is someone who actually has nothing to do with South Africa, but decides that he or she wants to come and study here. Now, the question then is, what is that person's right to education in South Africa? Well, before he gets onto the plane, what is his right to education in South Africa?
The person would have no right to education in South Africa unless said person actually intended of pursuing a career in South Africa.
No, but that's not true. That's not true. You can come here and you can do a degree in philosophy and go home again. You don't have to follow a career here. That's in fact not the idea, because you have a student loan. I mean, a student visa. You're here for 5 years, 10 years, then you have to go. Then you have to leave.
I was answering the question based on the fact that the person hasn't yet made efforts to study.
Yeah, but he doesn't come here so that he can follow a career in South Africa. But before he gets onto the plane, he has no right to education in South Africa. Now that he gets off the plane in South Africa, so he's here, does he have any particular rights to education or future education or more education?
Not unless he makes his intention clear, whether he intends to stay here for a prolonged period of time, and also whether he intends on staying here for the purpose of study.
You see, if he has a student visa for 3 years, then after 3 years, that's it. Then he studied as much as he can and he has to go home. Isn't that right?
Not necessarily.
Well, you mean he can get an extension?
Yes.
But if he doesn't, then he goes back. Then he
Yes.
leaves. Now, if his visa says you can study in LB, does he have a right to do PVT?
No.
Which means that he doesn't acquire rights just because he's here. He gets a permit or a visa or something to say how long he can stay here, and depending on what that is, he can do whatever that permits him to do. Do you agree with that?
Yes.
Well, the court has said that for only locals to be able to practice as legal representatives, that is not discriminatory.
Yes, that is not discriminatory, sir.
Now, the question then is that this is the applicant's case, and that is, the applicant says that when a foreign national, who's not, nationality is unimportant in a sense, it is all a question of residence. So there's a foreign student that has an LLB, but now is in a position where that person can't become a legal practitioner, as is envisaged in Section 5J of the LPA. That person effectively has reached a dead end. And the question then is, why should that person be allowed to go down the road, get another qualification that is meaningless, the applicant says, in circumstances where we're depriving a local who can become a legal practitioner from pursuing that? Isn't that right?
I'd like to argue that it's not meaningless for the foreign national to actually participate in PVT programs. However, I do agree that it would be pointless if they participated in candidate trainee programs.
Yes, no, well, it, of course, isn't meaningless. Any learning has value. And that person can do something else in South Africa and may be able to go back to non-SA land and and become an advocate there with the experience of PVT. That's not the question. The question is that the purpose of PVT? Isn't it to assist someone in becoming qualified? That is what Section 5J is all about.
Well, if you look at PVT programs, they don't only list that as its main purpose. Its purpose is also intended at re-educating legal practitioners that have already become practicing legal practitioners. in understanding how applications are made and how to properly make applications. So the reason why I argue for the inclusion in PVTs is for, at a later stage, a foreign national might want to institute certain proceedings in a South African court. He or she needs to know which forms to apply and which principles to follow when applying in those courts.
But of course, what you're saying is that if the Department of Home Affairs has given someone a student visa that is not limited, why can't that person do what a person can do when they study in South Africa? That's what you...
No, I'm saying that if they have that permission, unlimited permission to study in South Africa, they are entitled to study
and do a PVC. Yeah.
Mr. McIntyre, yes. I have to thank you because this amicus has truly assisted me. First with your lead counsel, and now your submissions are predominantly based on the minority rights. Is that correct?
Yes.
And as I'm deliberating upon your submissions, the words to the effect by Chief Justice Chaskilton came to mind in the Makanwanya case, where he said it is only when the weakest and worst of us are protected that the rest of us are protected, or words to that effect. So, you've heard, I have asked all the counsel about Section 5J and the Legal Practice Act, and the importance of that. And taking into account your contribution as an amicus curiae, it now comes to the fore that Section 5J is adopted by Parliament, and Parliament is the democracy, so it's majority rights by those that can vote. And it makes complete sense that that section is in favour of South Africans, which it is, and your lead counsel had indicated that this is quite dangerous. And understanding and thinking about what the Chief Justice Chaskilton had said about minority rights and taking your submissions into account, the point of the Constitution, and one of the reasons that we have constitutionalized and entrenched human rights, is to ensure that we are not simply ruled by a majority, and that the Constitution is there to protect those that don't have the mass pull in terms of the voting power, so that human rights are never truly impaired as they were historically. So for those reasons, I want to thank you. Now, this is the difficulty that I'd like your submissions on. There's no challenge to Section 5J, so we don't need to determine whether Section 5J is constitutional or not. It stands. That's the law. So if Section 5J stands, which is, you've heard on numerous occasions, then do we need to look further? Can we just, on this particular case, can we say that the question can be answered and we need not engage with Section 22, Section 9, Section 10, and any of the other rights, if we find the answer in the Legal Practice Act on this particular suit before?
I believe that everything must be in line with the Constitution, and first and foremost, the Constitution should be consulted first before pursuing any matter further, and only the Constitution can dictate to you, not dictate, can, what's the word that I'm looking for? Can help you arrive at a decision as to whether to pursue this matter further or not. But I definitely do believe that Section 5J should be looked into again.
You see, when I engaged with the respondent's junior counsel, she raised the question of transformative constitutionalism, meaning, you know, we are living constitution. We are striving to be transformative. And, you know, so that entrenched human rights are there for everyone, where the Constitution mentions it, and for citizens where the Constitution mentions it. So, on that basis, you're saying that I've asked you, can we not stop our inquiry at the Legal Practice Act if we find that it does answer our question? Of course, if it doesn't answer our question, we delve deeper. But if it answers our question, then I asked the Respondents' Council that, and she said, yes, if it answers the question, we are welcome to stop. The reason that that is important is because of the principle of subsidiarity, meaning, you know, the Constitution is a very powerful tool, and we are a bit further away from the democracy and so if a statute can answer that, should we not allow that? Is that not our obligation to only have recourse to invoking the power and the might of this court if the statutes cannot answer that definitively? So we first look to the closer piece of regulation or law that speaks to that point. And then, if that fails, then we take a next step. Because it is simply like, why use an AK to open a door? I mean, if you can use a door handle. So you don't...
I always use the AK.
So what I'm trying to express upon you is that there's merit in much of the submissions. And I've shared with you my difficulties, and I want to thank you for your contribution on the minority rights. And do you have an answer on if I find that my solution is in the Legal Practice Act as it stands, do I need to take a step further and interrogate further? What's your response to that? You've heard the Respondents' Junior Council on that. I've explained to you the subsidiarity principle and why I'm asking about that. And I'd like your definitive submission on that.
I believe that we do definitely need to look into it further.
Look into what?
Into Section 5J, and even if the solution is contained in the LPA, is it LPA?
So are you saying that we must look into it not from the point of view that it's not before the court on its constitutionality, but we should look into it from an interpretation point of view?
Yes.
Thank you for your submissions.
Thank you. As it pleases the court.
As it pleases the court, Section 29 of the Constitution allows for everyone to have an education, which is the LLB degree. But in terms of PVT, it is further training which is leading to admission. So we are submitting to the court that PVT then ceases when it relates to Section 29. In the matter of South African Diamond Procedure Organization versus Minister of Minerals and Energy, the court held that Section 22 comprises of two elements. For instance, the right to choose a trade, occupation, or profession freely, and the practice of a trade, occupation, or profession may be regulated by the law. According to the Constitutional Court, both the choice of trade and the practice are protected by Section 22 of the Constitution. Any limitations imposed on either of the choices or the practice should invite constitutional scrutiny. The Constitutional Court stated that if a legislative provision would, if analyzed objectively, have a negative impact on the choice of trade, occupation, or profession, it must be tested in terms of the criterion of reasonableness as according to Section 36, subsection 1 of the Constitution. If, however, the provision only regulates the practice of that trade and does not negatively affect the choice of trade, occupation, or profession, the provision will pass constitutional muster as long as it passes the rationality test and does not violate any rights in the Bill of Rights. A law prohibiting certain persons from entering into specific trade or providing that certain persons may no longer continue to practice that trade would limit the choice and element of Section 22. In Rafanaka versus Minister of Justice and Correctional Services, the court held that Section 22 of the Constitution is silent, non-citizens, therefore, does not afford the right to them. When students who are neither citizens nor permanent residents or citizens of the country choose to study, they do so with the knowledge of the fact that they will not be eligible to practice law in South Africa. We differentiate between citizens and permanent residents on one hand and foreign nationals on the other hand, and this does not amount to discrimination, which is unfair. Citizenship is not listed in the grounds of Section 9 of the Constitution and does not fall within the ground of social origin. This case was then dismissed by the High Court to order it as invalid. In terms of Section 5, subsection J of the LPA, it ensures accessibility and sustainable training for law graduates aspiring to be admitted and enrolled as legal practitioners. The applicant's right in this instance was infringed as she was not able to access the sustainable training. We submit to the court that Section 22 of the Constitution of South Africa guarantees every citizen the right to choose their trade, occupation, or profession freely. It emphasizes the importance of free, fair, and regular elections as fundamental to democracy in South Africa. This section also outlines the principles that govern these elections, ensuring that they are conducted in a manner that upholds democratic values of transparency, fairness, and accountability. Section 36 of the South African Constitution deals with the limitation of rights in certain circumstances. It states that the rights in the Bill of Rights may be limited only in terms of law of general application to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom. When analyzing Section 22 in conjunction with Section 36, it means that while Section 22 guarantees the right to trade, occupation, and profession freely, this right can be limited if such limitations are intact by law and meet the criteria of reasonableness and justifiability in a democratic society. This allows for balancing of individual rights with the broader interest of society, ensuring that any restrictions placed on the rights of political participation are fair, necessary, and are in line with the values enriched in the Constitution. We submit to the court that non-South Africans should be limited to participation because provision then applies generally to everyone who is non-South African, and in terms of Section 36, subsection 1 of the Constitution, this then would be justified.
Yes, thank you. There's just something that I want you to address, considering that this is a reply to what your opponents had to say. But if I understood the counsel for the amicus, the suggestion is that PVT is not an essential requirement for admission as an attorney, for instance. Do you agree with that? I thought it was.
I do agree.
Is that correct?
That's great.
The after one does an LB to become an attorney, you have to do some practical stuff. Always used to be called articles if you wanted to be an attorney, and there was 2 years of something you had to do, and you had to write an exam and you then had to pass, and if you did that then you could become an attorney. Now, is that what you have to do? Is that PVT, which means that if you don't do PVT you can't become an attorney? Or can you become an attorney without doing PVT?
You cannot become an attorney without PVT.
Thank you. I think we've concluded your argument, and in that process we've concluded all the arguments. Now, what is going to happen now, and you may be seated again. You may be seated again.
I may do what?
You may sit again.
Or I may be seated.
You can stand there too. But, so we've by and large done the court session. I think we'll just go behind closed doors and decide on the awards. I'm not sure whether you know this, but we're not going to give a judgment. The judgment will be meaningless, have no value. Who's going to look at it? And anyway, we don't know what the answer is. Or we do, I don't know. But it's, yeah, so for purposes of what's happened in these proceedings, we'll reserve judgment. So shall we adjourn now, and then when we're ready, we'll make our return known, and then we'll tell you, we'll sort of chat about what's happened.
So, you know, the purpose of counsel in a court is to assist the bench. So whoever you're persuading to, you are assisting. So from that point of view, when I was reading your heads of argument, I must tell you, I found it very useful. Indeed, you don't have official training on how to craft particular documents because you haven't been trained. So I understood that, but I looked beyond and I looked at the substance, and it truly, every single heads of argument that was presented to me impacted my thinking. So I want to thank you for that, because clearly there was a lot of effort and intelligence that went into the crafting of your submissions to court. So if I speak to the applicant's heads of argument, what I would find as counsel, and I did it as well when I started out, you started off, and I did it as well, we're too differential. So generally, you know, when we started court, we are so subservient to the judiciary and to the bench, and like, as it pleases the court, whatever the court wishes, and you are holier than thou. But that's not the job of counsel. Yes, you do not disagree with the bench. You, with respect, submit. So there is a delicate dance between the judiciary and counsel on how you have a discourse respectfully, and that's your training. Because remember, anybody else can come and just say what they want. That's why there is the right of appearance, so that you are trained on how to address and present submissions. And in a court, it's my learned brother, the bench says my learned brother, you say my learned friend. So whilst Advocate Marais SC was the Chief Justice in this court, I called him my learned brother, and he highlighted that it's not what I think. You know, we personally, it's your submission. So that's my training as well, and that was his training. So we are trained not to say, I think, and I think. It's what I submit. But of course, because you might have your personal views. So, and part of it is to pull yourself back and be able to make submissions on the law and what the law says on that particular facts. And in that way, you can always be objective and not need to become a little bit too emotive about it or to personalize, because then it loses the substance of the argument. You have more cogency because then you have reason and law that is supporting the way forward. So I found that the applicants' heads of argument were too differential, too respectful, too like, you know, you are up there and who am I? And you find like, yes. So yes, respect is important, but what counsel, and I learned this after many years, what counsel needs to do is you need to strategize and drive where the court is headed. And your delicate dance is always taking the judge to a particular point. So you have to strategy. I mean, I would say as an advocate, one of my key tools is to be strategic. It's higher level thinking. But you don't only use strategy, because strategy has different points. You know, there's certain objectives. So maybe I'm going to yield on this point to gain a different point. So you need to already think about what the bench is going to ask you and be ready for the answer. So, and strategize. So it's a delicate dance. So on that point of view, I would say that the applicant's heads of argument, you need to be a little bit more assertive on where you're taking the bench with your heads of argument. Amicus Curiae, I appreciate it a lot because they clearly told me that you did your job, because your job is not to rehash the applicant and respondent's case. Your job is to bring something on fact or law that can assist the court. So I did find that you brought Section 9 and you brought in the dignity. So you did bring different elements that assisted the court. And what I liked about your heads of argument was succinct. You know, I quickly it didn't take me long to understand what you were saying. I appreciated that. So it was to the point. Respondents' heads of argument was remarkable. It was really, really, you know, I went on an intellectual journey that I was really enjoying, and then I had to stop, you know, and that's what we all do. We go on intellectual journeys, and if you don't enjoy that, then you're in the wrong profession. So that's what we are engaging on certain points. I mean, intellectually. So I really enjoyed where you were leading me. And then I stopped here and there, and then I'm like, I can't recall if it was your head's argument or one of the others, but somewhere there's a footnote, Section 22. And I'm thinking, oh, okay, you put in the footnote, what Section 22? When I read the footnote, it says Section 22. So you're telling me in the footnote, this is the section, and then the footnote tells me exactly this is the section. But it doesn't tell me, it's a repeated, it was a surprise to me, I've never seen that done. So that's not a footnote. A footnote is Section 22, and then you footnote, and then you explain that. And then what it brought to mind is there is a debate between counsel. There's different schools of thought on footnotes. So there is a thinking from some leading jurists that, you know, anything important shouldn't be in a footnote when you're advancing heads of argument, because you want the attention to be in the document. So that's one school of thought. And I mean, it's something I've delved upon, thought about deeply. And I'm inclined to agree that anything important, you want to seize the judge's attention, and peripheral things may go in footnotes. So some people don't even want footnotes in heads of argument. So there is, remember, counsel is in the art of persuasion. So you are here to persuade. And you need to know where you're headed to persuade. You need to know, and it's quite easy for counsel, because your client has told you where they want to be. So it's not as if you need to rehash a case. Your client has already told you, look, this offends me. Now all you need to do is look at the law, and then what does the law say, and how do you best support that case? Your job as counsel, and I've made this like, counsel is not the judge, but you need to understand what the judge may do in order to advance cases, to direct the judge and to answer the questions. But you're not the judge. So don't make the mistake of being definitive in your view. You're just directing the judge. And then, yes, everybody needs to know what their prayers are. What do you want the court to find is the most important thing. So ordinarily, I didn't ask for this in this case, but what we probably should have done, because most courts do it, is say, with your heads of argument, file a draft order. I think I'll probably do it for the future courts, because we're all learning on how to improve, but this is what courts are doing. They are, you know, because then you actually think, okay, I want the court to dismiss. It's a little bit easier for the respondent because you want the court to dismiss it, and you may want costs. And then the applicant, maybe you need to couch the draft order. So you have to know what you want from the court. It's practical. It's not a doctorate. It's a practical application of the law. What I found, and check the law. So we had an issue because when I read, I was like enjoying what the respondents were saying and the law, and then I was like, oh, okay, does this Immigration Act say this? This is really like, because this really is persuasive in a completely different way because we're bound by the law. So I looked at it, and it wasn't what the heads of argument said and what the Immigration Act said. It was chalk and cheese. So I would say be very careful. In courts, I mean, this is critical to your reputation. A judge needs to know that when Advocate Makwara or Advocate Zulu makes a submission, they have thoroughly assessed the legal point. They know that this is what the law has said. They're not misquoting. Because what you're doing is then you're building reliability. Because remember, you appear again and again. Because then I know, okay, if Advocate Makwara, I know she's thorough. She would have checked it thoroughly. She's not going to make that submission. Then I must have misread it. I'm going to read it again. But the minute you start giving false, you make mistakes like that. It's not deceptive. I mean, I'm not saying any of you tried to deceive us. There's no benefit. This is a training court. But someone might say that you are misleading the court, and they pull you up in front of a professional body. You see? So it's vital, and if there's two of you, I would always then implicate the senior. I ordinarily would say the senior takes the knock for the end product. So it's always on the lead count, for me. I mean, different person, but truly the senior leads the junior. So you have to, if you walk away with nothing else from today, is that do not make a submission on law that is inaccurate. And if it ever happens, then you need to make up to this court by appearing with the best appearances ever, because that judge hasn't forgotten. They know that you made a false submission on the law, and they won't trust your submissions. So, and that also works with opposition, because you'll find you'll have engagements with opposing counsel. So what I find is, the person that told me this in my formative years is now a judge, leading in the judiciary. But when I was still very young, in my practice, I had the benefit of mentors as well. And he said to me, if nothing else, all you want is respect. So you're not looking to be liked. Don't aim for your opponents to like you, for the bench to like you. But when they walk away, they must respect you as counsel. And ever since I had that advice, that's actually it's invaluable, it's priceless. And that comes into being on your work ethic. It comes into being that I know, okay, if Advocate Makwara or Advocate Rodda is making submissions, there's truly no other point that can be advanced because they are so thorough. So you are looking to build, it's a very small fraternity or community, because some women activists don't like the word fraternity. Fraternity has a male connotation, so they push for the word community. So we all start to know each other, and I know, okay, this person, you start developing a reputation that this person is going to say whatever needs to be said to get the award or get the order. But that is not what you need to do. You also have a duty to put to the court what is against your client. And then what you do in that case is then you say, okay, this is purportedly against my client, but I can deal with it on this particular basis. That's how you need to do it. So from that point of view, your heads of argument were all useful for me. I've indicated what I think the errors were. And the oral appearances, I would say, no, thank you. I appreciate it. From oral appearances, what can I share with you from my experience? Perhaps I should leave it. I've dealt extensively with the heads of argument. Let me allow you to deal with aspects that I have in common.
Well, I'm going to say one or two things about the heads nonetheless. Is this on? I think it is. Considering that we don't have that much time. But what is important, though, is the heads are your first introduction to the bench. The bench sees nothing else. In fact, the first thing a judge ever reads are the heads. A judge reads your heads before they read the case, the affidavits, the evidence, whatever it is. They always look at your heads first because they want to know what the case is about and what you're going to say and what they should look for when they read the rest of the documents. Now, what you put in your heads, you actually want to have persuaded the judge of your point of view before you even get into the court. So that is why it's that important. So it's very important that you structure it well, that it's sort of logically set out. In my view, it should even be, the typing should look nice. It shouldn't look like you typed it yourself. But you want it to look like a professional job. What also is important is not to put in gumph that shouldn't belong there. I mean, you don't want to bore someone because, the moment the judge looks at it and sees he has 70 pages to read, and he reads through a lot of things that are clearly irrelevant, then it starts detracting from it all. Now, I agree with my sister about the quality of your heads, but there's another thing that I should point out, and that is that if you have to answer 5 questions or 6 questions, you must pertinently deal with those 6 questions. You say you want to know what is 4 plus 4. Well, the answer is 8. You have to deal with it as a category on its own, not dealing with anything else. You have to answer that question. Then you go to the next question. Now, to some extent, the applicant did that. The only thing is that the applicant said, well, the question is this, which means this, but it doesn't tell us what you want, what you say is correct, how you want that question to be answered. The third aspect is the one about footnotes. I think it is correct. The important things have to be in the body, and you would normally put the extra data that you don't want to labor the reader with. You put that in the footnote. But strangely enough, for instance, when you put something in brackets, that means, in a sense, that it's not that important. But sometimes by putting it in brackets, you make it more important. So, it's a question of experience over time as to what you think the effect of that is. As far as the of an error is that you made, learn from it and move on. Don't chastise yourself. There's always a lesson to be learned, but move on. Okay. The last aspect in this regard is the fact that we operate in a small community. Of course we operate in a small community because the LPC only allows 1 out of 10 applicants into the profession. When it comes to to argument, well, I don't know what it was like for you, but it can be frightening to stand there. Also in the SCA, there's a little spot. And not only is it frightening, but you've stood where other people have stood. And they were the greats. I mean, it's not easy. And I thought you all dealt with the pressure well. You didn't seem that nerves got the better of you. But And for instance, Ms. Zulu was even better in reply. I think she got used to this all. And of course, she had the difficulty that she was breaking the ice, and she was the first to speak. But I thought that you all spoke well, and you were gutsy, and you didn't wilt, and you kept going. I don't know whether I should even mention this, but the junior counsel for the respondent had a way of not looking at us. You're looking at me now, but the only reason why I mention that is, I think when you stand there and you have to look at us, that is quite uncomfortable. But you argued exceptionally well, but quite exceptionally well. But a bit of eye contact helps a lot. And in fact, I'll now give you another tip whilst I'm in the process, and that is, often when you appear before a bench that consists of more than one person, like here, or ultimately, when this whole bench is fully panelled, what is often quite useful is to try and identify that judge, let's say out of the three of us, who you think is more likely to be in your favour. Sometimes from questions and things that you can see, you may think, this is the guy that I can persuade. Because ultimately, what normally happens is that everyone's addressed, and then the judges go and deliberate as to what they think. But you want someone of those 3 or 11 or 5 or whoever to speak on your behalf. And the easiest is to at least know that you persuaded one person. And that's the person to whom you have to look. You don't even have to look at everybody. Make eye contact with that guy. When I say guy, I include women. But that's the idea is, that eye contact is very important. Then, whilst I'm sort of at it, I thought that lead counsel for the respondent argued so well, but was maybe just a bit too fast. Some people just think quickly. What can you do? But it was. I actually thought the standard of the address was quite. Your mic is on. I don't know whether that matters. But as far as the other counsel is, I'm not saying anything specific about you because, you all did a good job considering that you're very inexperienced. And you've done as well as any other counsel that I've seen. So, well done. Is there anything else I have to say? Charlene, is there something you want to say?
Well, I suppose perhaps you're all feeling a little more comfortable than you're here today when you all meet for the first time. Like my colleagues have said, congratulations. This is by no means an easy task, even if it is just a moot court. Rising in these benches in front of a full bench or 3 other advocates, I certainly know in my first year it was not something small for me. Since you already have received very good feedback at the end there, a little critique perhaps, I should come down a little harder. Not really. I agree with the comments of my colleagues. Also for the applicant, both of you. I could obviously and naturally, as was the case with all the teams, as all of you started, it was quite obvious that you are nervous. But there is one thing that I always enjoy listening to advocates argue, and that is that moment where, and I sometimes like today have to refrain myself from interrupting and saying, stop, take a breath. But it's almost that moment when that second breath comes and you realize reading off a piece of paper is going to do me no good. I have the argument here and I have it here. And it's literally that, and then you start advocating. And all of you had distinct, I noticed, and I specifically looked for it, all of you had that distinct moment where the second breath came. Both counsel for the respondent did that exceptionally well. I felt like, especially when the questions were put to you, obviously, that you were not prepared to receive or didn't know you were going to receive. But again, I thought all of you did really, really well once you had sort of reached that stage of comfort. And, you know, the guns the starting gun to the race has fired, so the nerves are over. I also really did like how all of you engaged with all of us and how you looked, whichever one of us posed a question to you. Of course, when you are addressing the court in a scenario where you have 3 judges or more on the bench, you do ideally want to, at some stage or another, at least acknowledge each of them in one way. But when a specific judge directs a question at you, that is the judge that you do want to address in that moment. I thought that was brilliant. Counsel for the respondent, and before you get to become too hard on yourself for what I'm about to say, bear in mind 17 years ago when I stepped into a moot court for the very first time in front of 2 SCA judges, I made the same mistake. I'm only telling you this because if you do make that in a real court, there will be some consequences. I noticed that when you arrived a minute or so after we had come back from the adjournment for tea, you robed in court. And again, don't be too hard on yourself. I made the exact same mistake and got 2 of the world's worst frowns from those judges that you can ever imagine.
Yeah, it's terrible.
For future, it is that, you know the phrase, it is frowned upon. I'm pretty sure that's where it comes from. It is extremely frowned upon by judges and a sign of the utmost disrespect. In future, if you are late to enter the courtroom and you realize I have left or I've forgotten my robe in court, the appropriate way to deal with that is to come inside to collect your robe, exit the court again and robe yourself properly outside. You're also not allowed to address the court if you're not properly robed. So again, that's just because I've been there, I've learned from my own mistakes, just a heads up to any of you. If that ever does happen, that is also why ideally whenever you leave a courtroom, whether it's in lunch, especially when the court adjourns, you always take your robes with you. Because if you're not back in time or back before the judge enters the courtroom, you're left in an embarrassing situation where you are without robes and now have to enter the courtroom without robes. So that was just that. Let me just think. I think the rest I wanted to say has already been emphasized by my colleagues. But overall, like I said, I really was very impressed. I don't think the 3 of us went easy on you guys at all today. I mean, at the best of times, constitutional issues are always difficult because, as I stated to some of you, you're weighing up to equally important rights or scenarios, whatever the case may be. So this was never going to be easy, and I thought all of you handled it exceptionally well. You should be very proud.
I just want to follow up on that. So, yes, indeed. We are only allowed to sit in the gallery if we don't have a robe. So you know, if someday I don't have a robe but I want to sit at the back, then I can sit at the back as normal. But you don't address the court without a robe. I just want to follow up and just say that, look, your confidence and your indicated your preparation, and everyone here prepared. So I want to thank you for that. And any judge, if you prepare, they appreciate it so much because the workload of a judge is just phenomenal. So when counsel helps the judge with good preparation, it eases the workload because they have so much reading to do. And if you highlight and you don't put in unnecessary, like, you know, you conflate it with unnecessary issues. So just zone in the point. So preparation is always cardinal. Preparation is critical to execution. Without prep, your execution will fail, no matter how good an orator you are. So that's the one point. And then your heads of argument, there was something I wanted to say about the heads of argument, that it was, I'll just share with you my experience from like on my feet. When I started out, heads of argument was now, okay, I've drafted, this is what I'm going into court with. And this was my argument. After practical experience, this is what I do now. I do my heads of argument knowing this is my written document, which will be there as the first introduction to the case from me and introducing me to the judge. So I draft it as my written presentation. Remember now, when we present, you've got a different audience. So I know that my judge may be sitting, he may be reading it. I want my font to be legible. I don't want blurred pages. So you think of all those things. You don't want someone to struggle in a font of 11 and, so you think of who the person is and the reader, and I present in that particular fashion. And maybe, he doesn't have an idea of the case, or she doesn't, so you start off on that basis where you quickly, later I'll go into depth, but I now draft with a clear idea of who is sitting and reading. So you need to know it's a judge, and it may not be somebody that has your visibility at that particular age, and it's someone that's very busy, that just wants to see quickly what the issue is, and then once I've grabbed their attention, wait, what do you want to say about this point? You grabbed my attention, I went further to look at the clause. I wanted to see what it says, and then didn't correspond. So you need to first grab the attention and make your reader want more. So that's it. Then, after I learned about that, then I realized, okay, when heads of argument are filed, and then your appearance is way later, it's not close. So then I stopped relying on my heads of argument. Yes, I know what my case is, but then I re-prepare the same case for an oral presentation. So that it's completely different prep. Because an oral presentation is this. It's like, how do you how do you present this on your feet? And you have to be more prepared than ever, because the judge will interrogate and jump in anyway. But you need to start off, and then they come and they interrupt and say whatever. But it's a different prep. That's what I've learned. I never prepare. So most people, when they're starting out, this is your heads of argument. They go to court, and this is the heads of argument. And I don't do that. This is my document I've prepared for that purpose. And later on in my mind, in the oral presentation, if I've omitted something, I know it's in my heads of argument. So it's never omitted. So sometimes on your feet, you haven't dealt with one issue, but in your heads it's covered everything. So sometimes they cut you short, but in your heads it's there. So the head should be as fully comprehensive. Your preparation must be fully comprehensive, but bear in mind, you're human, you may miss a point, but it's in your heads, and then you won't be beating yourself up, oh my word, I didn't address this. But also, the comforting thing, if it was critical, the judge would have asked you about it. So that's just something I've learned on my feet. Other than that, I think we will be ready to adjourn, and we thank the videographers. We don't require the recording for the next part. We will be then deliberating on the awards and presenting the awards. Thank you so much. We'll see you shortly.
All rise.
For the last time.
For the last time.